Let me know when we're live. All right. Welcome to the final round of the 2022 Hippard Open. Congratulations to Autumn Brigon, Joshua Hunter, and Jeff Krumpholz for making it this far. Here we're ready to see our champion. This is the final round. We have 3 judges: the Honorable John Herman, the Honorable Brett Hargis, and the Honorable Joshua Bennett. Thank you all for being here. Thank you for judging. Thank you to our viewers. This is a great way to watch 2 teams go head to head in trial. We're going to get started. Red Berry versus the Hard Luck Casino. This is the Court of Washingtonia. Welcome.
Okay, great. Calling the case of Red Berry versus Hard Luck Casino. Can I get appearances from counsel, please?
Good afternoon, Your Honor. Jeff Krumpholz for plaintiff Red Berry.
Joshua Hunter for the defendant, the Hard Luck Casino, and I'm joined by
Co-counsel Autumn Brigon.
All right, great. Thank you, counsel. Is there any housekeeping or anything else to take up the court before we get started?
Yes, Your Honor, we have several housekeeping issues. First of all, would the court care for a courtesy binder?
I would appreciate that. Thank you.
Oh.
Your Honor, in pre-conference, we agreed with the other side to pre-admit several exhibits. Would you like those numbers?
That would be great.
Those are exhibits. Exhibit 3. Also, Your Honor, a few other housekeeping matters. May we assume the jury charge will be read before closing?
Yes.
And do you prefer we ask to approach on every witness?
You can ask one time with the witness, and assuming I give you permission, just feel free to make reasonable use of that.
Thank you, Your Honor. And then do you prefer we stand or sit for examinations?
Do counsel have a preference that's unanimous?
Your Honor, may we question within reason from the well?
You may, as long as you don't have any issue with that.
I would prefer to use a podium or be seated just to have materials handy. Have you all been using a podium?
No, I think we just wanted to be considerate of everyone.
Sure, we'll call it dealer's choice. Do whatever you like.
Okay, perfect, Your Honor. And that's all the housekeeping matters for plaintiff.
A great defense.
Yes, Your Honor, we are ready to proceed to opening person to a few housekeeping matters. First of all, may we assume all witnesses have been pre-sworn?
Yes, you may.
May we assume that all exhibits have been pre-marked?
Have they?
Yes.
Then yes.
May we move freely about the well during opening vote?
Within reason.
Thank you, Your Honor. That concludes our housekeeping matters, and now we are ready to proceed to a motion to eliminate in 1 part.
Okay, and do both sides have motions they'd like to take up, or is it just defense?
I have a motion for the order.
Okay, as I understand it, procedurally, defense has the burden today, so I'll let defense have the first stab.
Yes, Your Honor. As you know, this is a fraud case in which the Hard Luck Casino has exercised its right to deny a wager that was placed fraudulently. In line with that, we believe that the plaintiff may attempt to elicit testimony regarding the casino wager policies. These policies are not an issue today. There are no contributory elements to fraud. As such, whether or not the casino followed its normal practices in how much money it accepted for each bet is not an issue in this case. And so it's irrelevant under 401, and it's also more prejudicial than probative under 403 because it confuses the issues.
Okay, any response to that?
Your Honor, we do plan to get into the casino's policies. They're relevant as far as certain witnesses' bias and credibility and motive for doing certain actions and denying my client a payout on his wagers. Their casino employee violated casino policy in order to approve my client's bets. So we absolutely want to get into the fact that her job was in jeopardy to show the court and the jury that there was an issue behind bias, motive, and credibility.
Okay, and I'll give you the last word as it relates to bias, reliability, and credibility. Is there still a reason that testimony shouldn't come in?
Yes, Your Honor, because counsel just slightly misstated the facts. The witness that will testify to this wager that was over their normal wager limit is the sports book manager. So it is her job to either approve or deny bets that are over the wager limit. She didn't violate the policy. Any bet over a certain number has to be reviewed by her.
And we will show otherwise, Your Honor.
Okay, it sounds like there's a fact issue here, and I'm not sure that even if I take your word on it, that this is the type of issue that could lead to a mistrial. So I'm going to deny that motion in limine. Do you have any other things for me?
No, Your Honor, that's it for the defense and motions.
Okay, plaintiff.
Your Honor, I move that certain information about my client Fred Berry's history in past casinos where he was banished for card counting not be mentioned in opening statement and also be excluded unless we approach first and speak to the court.
And what's the legal reason for excluding it?
Your Honor, if the defense goes into this issue, it will be for improper character evidence to show that because he was banished from prior casinos for card counting, that somehow would give him or make him more likely to defraud a sports bet in this case. So they're completely unrelated and it's just going to be used as improper character evidence.
Okay, defense, do you have any response to that?
Yes, Your Honor, we don't plan to elicit any testimony about Mr. Fred Berry's gambling history in our case in chief. However, if Mr. Berry attempts to bolster his credibility or otherwise opens the door to this gambling history, we would then approach and bring it up.
Okay, if you're agreeing to approach before you get into it, then I will grant the motion as unopposed and both sides just approach before we get into it.
And the second part of my motion, if I may, Your Honor.
You may.
Your Honor, our other witness today is Haywood Nelson, the offensive coordinator for the Cleveland Browns. If the defense intends to get into a certain disciplinary letter where Mr. Nelson was disciplined in writing by the NFL for accessing his phone during games over a year ago, then we would like to exclude this from being mentioned in opening statement or during trial unless we approach first. Your Honor, this as well will be used as improper character evidence, propensity evidence specifically.
Okay, any response?
Yes, Your Honor, we believe in its case in chief, the plaintiff will attempt to explain away Mr. Nelson having his phone by saying he never used or looked at it. At such time, his former discipline for attempting to conceal using his phone will be relevant. So again, while we don't plan to get into this in our case in chief, we do anticipate this will become relevant.
Okay, and should it become relevant, are you willing to approach before getting into it?
No, Your Honor, we think this is impeachment.
May I have the last word, Your Honor?
You may.
Your Honor, if our witness does not open the door, you heard from counsel's own mouth, they plan to use it as propensity evidence, which is improper. We believe for that reason, we should be approaching before we pick it up.
I think I heard impeachment, not propensity. I'm going to go ahead and punt this issue. I'm not sure I'm aware of the facts well enough to call it one way or the other. So if you feel anything improper is raised, feel free to object and we can talk about it. Otherwise, I'm going to withhold ruling on that motion.
And that's all for the plaintiff. Your Honor.
All right, great. Are we ready for openings?
Plaintiff's ready.
Yes, defense is ready, Your Honor.
Great. Defense, as I understand it, you have the burden, so feel free to open when you're ready.
Your Honor, may we invoke the rule at this time?
Is there any response to invoking the rule?
No, Your Honor.
Then the rule is constructively invoked. Thank you.
May it please the court. Cheaters never win. It may not be in the moment, but it always catches up with them because there are people who hold them accountable. My name is Autumn Brehon, and I'm joined with my co-counsel Joshua Hunter, and we represent the defendant in this case, the Hard Luck Casino. Now, this is a fraud case, and that means that we have the burden for you today. And we're going to prove that burden. And we're going to do that by pointing out all of the irregularities surrounding this bet and this game. So let's start with the bet. It's the morning of Friday, November 13th. And Fred Berry places a call. He calls his longtime friend from high school, Mr. Haywood Nelson. Now, Haywood Nelson isn't anybody. Haywood Nelson is the offensive coordinator for the Cleveland Browns. And after he placed that call, 1 hour later, Fred Berry walks into the Hard Luck Casino and he places two of the biggest bets he's ever placed in his life. Here comes Sunday, November 15th. It's football Sunday. Millions of Americans are watching the game. And what they see is an individual named Nick Chubb running down the field. There are no defenders behind him. There's nothing but grass in front of him. And instead of crossing that touchdown line, he steps out of bounds. What millions of Americans don't see is that Fred Berry is on the phone, sending instructions to Haywood Nelson. Now, as the offensive coordinator for the Cleveland Browns, Haywood Nelson is one of the only individuals with a direct line of communication to players on the field. Sending instructions, he's got to get in the game. Tell him to stop. That's enough. And at the end of the game, both of Mr. Berry's bets, they win. And the very next morning, on November 16th, Mr. Berry wires Mr. Haywood Nelson $64,000. As the defense, you're going to meet two individuals who are the most intimately connected with the bet that was placed at the Hard Luck Casino on Friday, November 13th. You're going to meet Mabel King. Now, Mabel King is the sports book manager with years of experience in sports betting. And she's going to sit there and you're going to hear her talk about all of the irregularities surrounding that bet that Mr. Berry placed. The second individual that you're going to meet is Dee Thomas. Dee Thomas is probably the one person in this room with the most experience investigating this type of fraud. And she has spent considerable hours and considerable time investigating the nature surrounding that bet. And she's going to walk you through that investigation. And at the end of that investigation, and at the end of our case, my co-counsel, Mr. Hunter, is going to come speak to you again. And when he comes to speak to you, he's going to overview all of the relevant testimony that you've heard and all of the relevant information that matters to making that decision today. And we are confident that you will make the decision that the evidence supports and that justice demands, and that is to find the Hard Luck Casino not liable for paying that bet to Mr. Fred Berry. Because again, cheaters never win when there are people who hold them accountable.
Counselor, plaintiff, would you like to make your opening at this time?
Yes, the plaintiff would, Your Honor. Let me have a moment to prepare the well.
Oh, could I see that, Counselor? I've never seen this thing. Thank you.
May it please the court. Opposing counsel. Members of the jury. The House always wins. But why is that? My client, Fred Berry, went and he made two bets on November 13th, 2020. You're going to hear the story today of how and why he made those bets. By way of introduction, my name is Jeff Krumpholz. I am proud to represent Mr. Berry. Now, we're not going to hide that Mr. Berry knows somebody very important to this case. He knows Cleveland's offensive coordinator, a man named Haywood Nelson. We're not going to hide from you that my client, Fred Berry, donated $64,000 to a fundraiser that Mr. Nelson had started for their high school. Mr. Berry and Haywood Nelson went to high school together. Now, these aren't the facts that are going to hurt anybody, but the defense, we anticipate, will come to you with a different story. The story I'm going to bring you today is how Fred Berry, a man who knows stocks, a man who understands sports betting, saw an opportunity and he placed two very large bets. He did so legally. He did so timely. And when he went to collect from the casino turned him down. Members of the jury, this is a case about David and Goliath. Only Goliath owes David money. Now, we're going to put Fred Berry on the stand today, and Mr. Berry is going to tell you in very plain words what he does for a living, what he saw in these bets, and why he made them. We're also going to bring you Cleveland's offensive coordinator, Haywood Nelson. Haywood Nelson is going to testify under oath that he has never talked to Mr. Berry about his bets. At the end of the day, the defense, the casino, is going to bring you Facebook posts and phone calls. I don't know. But they're not going to be able to show you fraud, and that's the F word that matters. This case is about accusations of fraud. Now, as opposing counsel mentioned, the defense has all the burden today. They have the entire burden to prove fraud by clear and convincing evidence. We have no burden today. We have no burden because if the defense does not meet their burden, we don't have to prove anything else. Now, by the end of this trial, we're going to come back to you, and it's going to be very clear why it is the House always wins. And we're going to ask you to do something about it. Thank you.
Thank you, Counselor. Defense, would you like to call your first witness?
Yes, Your Honor, at this time, the defense calls Mr. Mabel King to the stand.
Okay. Mr. King, I'd like to remind you that you remain under oath.
May I proceed?
You may.
Make sure the witness scoot your chair all the way down to the end of it.
Counsel, I'm gonna take you for the vote.
Like, yeah.
May I proceed?
You may.
Good afternoon, Mr. King. Could you introduce yourself to the jury?
Yes, hello, good afternoon. My name is Mabel King.
And Mr. King, what is your connection to this case?
Yeah, so actually I'm employed by Hippard Casino. I'm the sportsbook manager there.
Do you know what this case is about?
Yes, I do know. It's about two bets placed at our casino that they found to be fraudulent.
Objection, legal conclusion. Response?
Yeah, that term just happens to also be a term that they use in the casino industry. Mr. King is going to testify that he specifically instructed someone to look for fraud. That's just what they call it.
Okay, I'm gonna overrule at the moment, but feel free to re-urge it if you need.
Mr. King, you said we refused to pay the bet. Are you involved in that decision?
Yes, I am.
So why is the Hard Luck Casino not paying Mr. Berry's bet?
So we believe after the events that transpired during the game that there may have been some cheating involved.
Okay, Mr. King, I want for you to tell us a little bit more about yourself. What exactly is a sportsbook manager?
So basically the sport books manager, we manage everything when it comes to sports betting. More importantly, like I specifically manage and decide what bets can and can't go through, and I'm able to approve higher bets.
You say approve higher bets. What do you mean by that?
So there's instances in which people want to, risk it all, put more money into a specific bet, and it comes down to me to decide whether I find that applicable.
So is there one number that you need above which that you need to review, or is it on a case by case basis?
It's dependent on the bet that we're looking at. Some bets have a higher limit than others lower.
For Mr. Berry's bets, bets like that?
Yes, they were well over the limit.
I want to shift gears specifically to Mr. Berry's bets. Did you review those bets?
Yes, I did.
Yeah, permission to approach the witness with what has been marked as pre-marked as exhibits 1 through 3, and also what has already been pre-admitted as exhibit 3. Mr. King, I've handed you what has been pre-marked as exhibit 1. Without telling us anything about it, do you recognize it?
Yes, I do.
What about exhibit number 2?
Yes, I do.
Can you tell us what exhibits 1 and 2 are?
They are betting slips for the 2 bets in question.
Now, did you review those betting slips in approving Mr. Berry's wager?
Yes, I did.
Does the Hard Luck Casino always print those receipts when people make bets?
Every bet gets one, yes.
Are those receipts printed at or around the time the bet is made?
Like right after the bet is placed.
Are those true and accurate copies of Mr. Berry's receipts that you reviewed?
They are, yes.
Yeah, at this time we need to admit exhibit 1 and 2 evidence.
Any objections?
Objection as to improper foundation.
Why don't we constructively approach and you tell me what was improper about the foundation?
Your Honor, he said true and accurate.
Gotcha. And Counselor, do you believe you've laid the correct foundation?
I do believe I said true and correct.
Would you like to take a step back and say true and correct, just so the record's clear?
I would.
Okay, let's give him that chance.
And are those true and correct copies of the betting slips you reviewed?
Yes, they are.
Yeah, at this time, we need to admit exhibit 1 and 2 evidence.
Any objections?
No objection.
All right, 1 and 2 are admitted.
May we publish them to the jury?
You may.
Mr. King, I'm about to ask you about some of those numbers on that betting slip. Do you think it would aid the jury in understanding your testimony if you could come up and write some of those numbers down?
I believe it would.
Yeah, permission for the witness to enter the well to construct the motion.
Permission granted.
Your Honor, may I reposition to be able to see the demonstrative force?
So, Mr. King, my first question is, does that betting slip tell you how much Mr. Berry put down at the casino on his bets?
It does.
Okay, could you tell us about that?
Okay, so what we call that in the industry would be the total stake, what he is putting out. So for that bet, the total stake for bet one was of 230,000.
What about his second best?
So same thing, total stake for bet number two was of 86,000.
And if you could, Mr. King, could you tell us how much total Mr. Berry put down on November 13th?
Yes, I could. That would be 316,000.
Now, correct me if I'm wrong. Well, I'm sorry, correct that. These two bets, are they related?
Yes, they're for the same game.
Is $316,000 a normal amount to put on one game?
Objection leading.
Any response?
I can rephrase.
Go ahead and rephrase them.
Does anything stand out to you about $316,000?
Yes, it does. It's a way larger quantity than what we usually see at the casino.
Now I want to shift gears and talk about how much money the casino would have had to give Mr. Berry had he won. So for the first bet, how much would he have gotten from the casino?
Okay, so for that, it would be the total payout. And let's mark it as TP, if that's okay.
That's fine.
And that for the bet number one, that would have been 430,000.
And what about for the second bet?
Same thing, total payout for number two would have been 550,000 with $400.
So how much total would Mr. Berry have gotten from the casino had his bets won?
So the total payout would have been $980,400.
I want to ask a question about that last total. Would the casino have been able to pay such a large number?
Yes, we could have.
How?
So what we would have had to do was use the losing bets to pay the majority of it, but we would have to put out of pocket from our casino a total of 80,000.
So are you saying you would have used $900,000 from the other bets to cover Mr. Berry's payout?
Objection leading.
Sustained.
So how much money from the other bets would you have used to pay Mr. Berry?
About 900,000.
Thank you, Mr. King. You can return to the stand. Now I want to turn to Mr. Berry's bet again. What was the first thing that made you suspicious of his bet?
Well, like I said, that's not a normal quantity that you see come into the casino. It was a very large bet in comparison to others.
Did anything else stick out to you about that specific bet?
Oh, yeah, I manage sports bookings, so I'm pretty in touch with what goes on in the NFL. And he was betting for the Texans, which, they're really
Objection is the narrative. The question called for a yes or no.
I would imagine if the question called for a yes or no, you would have probably objected to leading. So I'm gonna overrule the objection and just ask that the questions and answers be kept to Q&A format.
Yes, Sean. So if you were suspicious of the bet, why approve it?
So our books weren't balanced. All the bets were going on Cleveland's side because they were a better team. They were odds for them to win, so I had to balance my books.
What do you mean by balance?
So for every bet, there is a counterpart, and we try to keep those two at the same amount so that the casino doesn't go at a loss.
Is being out of balance risky?
Very much so.
Well, so what about Mr. Berry's bet? Was that risky?
Objection legal.
If you're willing to rephrase, go ahead.
What did you think of Mr. Berry's bet?
I thought it was a huge risk on his end and our end as well. I mean, as you could tell by the graph, the payout is, there's a big difference between the payout and his deposit, but like I said, I have to balance the books.
So what made balance in the book or the books being out of balance more risky than his large bet?
Because his large bet was like very low odds of hitting, and even if it did, there's always our policies which state that in case of like any cheating or fraud, we're able to basically toss the bet.
Is that something you suspected?
Once we watched the game, saw how it transpired, I watched Nick Chubb's interview, I did think it happened, yes.
Well, tell us a little bit more about that. What about the game was suspicious to you?
Well, as a football team, the point is to win games. As a running back, your job is to be a focal point in offense, especially scoring.
Objection as to improper opinion.
Why don't we constructively approach Counselor, tell me, is this witness a qualified expert in the scientific and technical know-how of football?
No, this witness is not. However, Your Honor, my questions was what made this witness suspicious. I think the jury can understand that they are hearing this witness's suspicions as to why they thought the end of the game was suspicious.
Okay, I'm going to sustain the objection to the extent that the witness was getting into expertise. If you'd like to ask the question again with the understanding that the answer should be limited to this factual witness firsthand knowledge, then that's fine.
Okay. Mr. King, what made you suspicious?
In my personal opinion, I was suspicious because, as I mentioned, Nick Chubb very oddly stepped out at the 1 yard line, and just what transpired with the game.
So then what did you do next?
As is policy with any suspicious bet, I called up our private investigator and had them look into it.
And what is your understanding, without getting into it, of what your investigator found?
So they found a connection with the Cleveland Browns offensive coordinator. And a donation that was made.
Objection, there's no foundation for this, Your Honor.
So in one succinct sentence, tell me what the objection is. The legal objection.
The legal objection is improper foundation for this opinion.
Okay, response.
I didn't ask for an opinion. I asked for the understanding of what the investigator found.
Okay, I will again sustain the objection to the extent that this is getting into opinion testimony. But should it be and remain limited to their understanding and how that impacted whatever they may have done, I'll allow that. And again, re-urge the objection if you feel like it gets into crossing that line.
So I'll ask again, Mr. King, what was your understanding of the result of what your investigator found?
So the result of the investigation I fought for came out to be that there was a connection.
Objection, Your Honor. It's testifying about someone else's opinion. At this point, it's hearsay.
Okay, what's your response to the hearsay objection?
Yana, this doesn't go to the truth of the matter asserted. It goes to the effect on the listener, Mr. King. Mr. King, if I'm allowed to continue, will
Why
tell
don't
me.
we constructively approach and then you can continue?
Okay, we are approached. Yana, Mr. King made the determination that there was fraud in this case. And Mr. King is about to tell the court why he found there was fraud in this case, namely the results of this investigation.
Okay, would you agree with me that whether something is fraudulent or not is potentially a legal conclusion?
Okay, Yana, maybe I can ask the question in a way that elicits a synonym for fraud.
Okay, at this time, I'll sustain the objection, but again, if there's a way to ask what you'd like, feel free.
So in layman's terms, Mr. King, what was the result of the investigation?
As I was reported by the person that I hired.
It is believed, objection to hearsay, as reported by the person hired, Your Honor.
Yeah, I'm gonna sustain the objection under the same grounds.
Your Honor, can I get an instruction for the jury to disregard what they've heard so far?
Sure, that short piece of testimony should be disregarded, jury, and it'll be stricken from the record.
If you could boil down the results of the investigation to one sentence, what was your understanding of what was found?
That my suspicions of cheating were correct.
And so then what did you do?
After that, we followed up with the casino and we go here to bed.
Mr. King, are you just claiming fraud because the casinos are so losing?
Objection to leading.
I'm gonna overrule the objection, but you should rephrase that.
Mr. King, are there any? Mr. King, are you sure this is fraud?
Objection calls for a legal conclusion.
I can rephrase again.
Rephrase.
Mr. King, are you sure Mr. Berry cheated?
Objection calls for speculation.
No, if the witness knows, they can answer.
I'm sorry, could you ask once more?
Are you sure Mr. Berry cheated?
Yes, I'm sure.
Thank you, Your Honor. I'm sorry. Thank you, Mr. King. Pass the witness.
Okay, cross exam,
May I proceed, Your Honor?
you may.
Good afternoon, Mr. King. Mr. King, you just said that you're sure that Fred Berry cheated, did you not?
I said that, yes.
And you're sure of that because of the results that your investigator found, correct?
Yes,
You did no investigating on your own, correct?
it's not my job.
Sir, that wasn't my question. My question was that you did no investigating on your own, correct?
I did not.
Sir, you're an accountant by trade, aren't you?
I'm a sports book manager, but yeah, you could probably,
So is that a yes to my question?
yes,
Sir, you understand that the casino makes money on every bet, no matter who wins or loses, right?
I think there's too many bets to say we make money in all.
Sir, you don't know how the casino makes bets,
I do,
makes money off of bets.
I do,
Okay, so you know then the casino makes a big off of every bet, right?
yes,
And you understand that the casino's job is to balance both sides of a bet so that the casino isn't in the hole after somebody wins a bet, right?
yes,
And sir, that's your job to oversee that, isn't it?
Yes,
And sir, you made a mistake in this matter because you approved 2 large bets by Fred Berry, didn't you?
I approved them, yes.
So is that a yes to that you made a mistake in doing so?
I don't think so.
You don't think you made a mistake? Right? Is that your testimony, sir?
Mm,
Sir, is that a yes?
yes,
So it is your testimony to this court and to this jury that by approving Fred Berry's large bets, you made no mistake. Is that correct?
well. There was some mistake on my end, yes, I took that back.
So now your testimony is that there was a mistake on your end.
Yes,
And sir, that mistake could have cost you your job, couldn't it?
they could, yes.
Because, sir, as opposing counsel put on this demonstrative right here, the casino is going to lose $80,000 because of this bet, right?
Yes,
And sir, that does not even count the bad beat insurance that you guys had to refund to other gamblers, correct?
yes,
Because as a matter of fact, your diamond medallion high rollers who lost this bet, you had to refund them money too, didn't you?
yes,
So you were in a lot of trouble at the casino, weren't you?
yes.
Now, sir, I want to ask you something about proposition bets, okay? A proposition bet is something that the casino comes up with, right?
Yes,
That's not something that a bettor walks into a casino and says, I have an idea, I want to bet on it, is it?
that's not,
The casino comes up with the criteria, right?
yes,
And sir, the casino sets the odds, right?
yes,
You saw exhibit 1 and 2, right, that has the betting tickets and all this information. May I, sir? May I approach, Your Honor?
You may, but you might ask first next time.
I will next time, Your Honor. My apologies. Sir, this is something the casino comes up with, isn't it?
yes,
These odds right here, minus 115, that's something you come up with as a casino.
yes,
And how much they're going to get paid if they win, that's something you come up with as a casino, right, sir?
yes,
Now, sir, just a few more questions here. You said the casino moved the betting line Friday before the game, right?
yes.
Now, do you recall specifically that the betting line before you changed it? Man, I forgot that. You recall that the betting line before you changed it was at Cleveland -3, right?
Yes,
And sir, you changed that because you had too many bettors on the Cleveland side, right?
yes,
So you wanted to entice bettors on the Houston side, right?
yes,
So you changed the line, didn't you?
I did,
You
yes,
changed it to Cleveland by 3.5.
yes,
So that's the old bet, or old line. This is the new line, 3.5. And so when you did that to entice bettors on the Houston side, Fred Berry was one of those bettors, wasn't he?
yes,
Fred Berry was going to save your bacon, right?
yes,
Because you were in the hole. You were in the hole, right?
yes,
And Fred Berry had some big money come in, right?
yes,
And you approved those bets.
I did.
Pass the witness.
Any redirect?
Yes, sir.
Mr. King, opposing counsel just asked you about bad beat insurance. Do you know what that is?
No.
No?
No.
It's okay if you don't know. Do you know?
No,
Would you like to have your recollection refreshed?
yes, that I have a reflection.
You remember before this trial, you answered a number of questions from the plaintiff's attorney.
Yes,
I was there. Right?
yes,
And you answered a few questions, right?
Objection leading.
I think he's orienting the witness, so I'm gonna allow it to a limited extent.
And Commissioner approach with answers to the plaintiff's interrogatories.
Okay.
Page 3. So, Mr. King, I'm gonna allow you to read this paragraph, just read it and let me know when you finish. Okay, so can you tell us what bad beat insurance is?
Would that be objection, Your Honor? The witness is reading.
Is there a legal objection?
There is, Your Honor, but I cannot recall it at the tip of my tongue.
Okay, assuming he's objecting to hearsay, what would your response be?
I'll just instruct the witness not to read it.
Great.
Okay. Without reading the paper, Mr. King, what is bad beat insurance?
it's an insurance that we have for certain customers that whenever something like what happened at the evening game happens, we with the back give them back the money.
So you return people's bet?
Yes,
No further questions, John. We move to preserve this demonstrative and ask that the witness be excused.
That may be preserved as defense demonstrative 1, no need to write on it, we all know. And you may be excused, Mr. King, thank you. Defense, would you like to call your next witness?
Yes, Your Honor. I call D. Thomas to stand.
Bailey, can we get a time check?
Give me 1 second while I do something.
Your Honor, while the bailiff is counting, may I prepare the well?
You may.
You have 46 minutes and 40 seconds left.
Thank you.
You're good.
46 minutes.
May I proceed?
You may.
Good afternoon, Mr. Thomas. Can you introduce yourself to the jury?
Yes, good afternoon, everyone. My name is D. Thomas.
And Mr. Thomas, what do you do for a living?
I am currently employed as a private investigator for the casino.
Do you have any certifications as a private investigator?
Yes, I have 2 certifications, one for the state of Americana and another one in the state of Nevada.
How many certifications do you have?
I have 2.
Do you know why you're here today?
Yes, I was called in because I'm here to attest to my reports in terms of finding potential fraud with various bet.
Objection as to narrative. Do you know why you're here today?
Okay, across the line, all overrule that.
Can you restate your answer for the jury? Why are you here today?
Yes, I was called in because I'm here to attest to my report of potential fraud found within Barry's bets.
So we're gonna go through your report. Do you believe it would help the jury for you to be able to write out the steps that you took as a demonstrative?
I believe so.
Your Honor, at this time, we ask that the witness be allowed to step down into the well to perform a demonstrative and that opposing counsel be allowed to move so they can see it.
That's fine to all of it.
Thank you. Thank you, Counsel.
Ms. Thomas, where did your investigation start?
Well, obviously.
Mr. Thomas, sorry.
Well, obviously, the heart of the matter of this whole allegation is the game itself, Cleveland versus the Texans. So that's naturally, that's where my investigation first started. So it first started by me viewing the game in full from beginning to end.
What did you do after you watched the end of the Cleveland Browns game versus the Texans?
I began to take a few key details about this game that were very particular and heightened my intrigue in terms of potential fraud. So for starters, it was the way it was around like the minute 13:32, Chubbs has scored one touchdown. And then after that moment, for 13 minutes, 32 seconds, he didn't score at all. Secondly, I would like to point out.
Objection to the narrative.
Sustained.
What was the second thing that you noticed that stood out to you about the game versus the Cleveland Browns and the Texans?
Secondly, it was the one instance where Chubbs himself was able to score a touchdown. But instead of going to it at the 1 yard line, it was said that he stepped out.
After you pointed out the instances that you noticed while you were reviewing the game, what did you do next?
Naturally, well, my final thing was that the post-game comments by Chubb saying that he was
Objection to hearsay.
Okay, let's constructively approach. And Counselor, why is this not hearsay?
Your Honor, the witness has not yet attested to any statement that was made. They are just explaining in the course of their investigation, the impression that they had in viewing a comment. It's not being admitted to assert the truth of the matter, but the impression that they had through the course of their investigation.
Okay, well then let's keep it limited to their impressions as opposed to the comments themselves. And so I will conditionally sustain the objection to that instruction.
After you watched the post-game comments, what was the impression that you walked away with?
My impression was that there might be something off about the end results of the game. So naturally, I decided to dive into the investigation.
What was the second step in your investigation after watching the clips and watching the end interview?
Well, after that, I decided to find any connection between Barry and the Cleveland Browns. Barry was the one who made bets involving this team.
How did you search for connections between Mr. Barry and the Browns?
I began scouring around the internet and I was able to stumble upon a Facebook post by Watts High School in terms of enclosing a picture of Freddie Barry and.
Objection to hearsay. Facts not in evidence.
Okay, how would you respond to the hearsay objection and were constructively approached?
Yes, Your Honor. One, I'm still asking for this sense of where they're at in their investigation. And if opposing counsel would have allowed, I was about to approach the witness with the actual exhibit.
So are you saying there's no hearsay yet?
There is no hearsay yet.
Okay, what about the facts not in evidence objection?
So far, all that the witnesses testified to is that they found a Facebook post. There's no statement that's being admitted. There's no statement being admitted for the truth of the matter.
May I respond, Your Honor?
You may.
I heard a comment about a Facebook post containing a picture. So we're now describing a Facebook post, which is why I made my objection.
May I briefly respond, Your Honor?
Before you do, so what you're saying is maybe it's a best evidence objection.
That better evidence would be the exhibit versus him testifying about the exhibit.
Okay, I'm going to overrule the objection. Please continue.
What was the second step in your investigation?
To reiterate, scoured online and I stumbled upon a Facebook post that enclosed a picture of.
Your Honor, at this time, I would like to approach the witness who has been pre-marked as Exhibit 4. Without getting into the contents of this, what is this document that you're looking at?
It is a Facebook post containing a photograph.
And how did you come across that photograph?
Again, I was scouring around the internet for things involving Mr. Berry and or the Cleveland Browns.
And is this a true and correct copy of the document that you found on Facebook?
Yes,
And is it a fair and accurate copy of the document that you found on Facebook?
yes, it is.
Your Honor, at this time, I move to publish Exhibit 4 into evidence, tender to opposing counsel and publish to the jury.
Okay, so as far as the first step, admitting it, are there any objections?
Yes, Your Honor, I would actually like to take the witness briefly on voir dire
On what grounds?
on the grounds that this appears to be some kind of high school photo, Your Honor, and if it is, I'm going to object to relevance.
What will you be voir diring the witness on though?
As to what time period, in his understanding, this photo comes from.
May I respond, Your Honor?
Let's constructively approach, and yes, you may.
If the witness is allowed to continue, they will attest to the time frame that's already clearly established in the photo. The witness has not yet attested that the photo represents anything that happened recently.
Your Honor, may I respond since we're at the bench on approach?
You may, but let's make it brief.
This will be very brief. This is a picture of two very young guys, and as you can see, my client is clearly not this same young guy anymore, Your Honor. So the relevance, I'm still not clear about if this is an old Facebook or high school photo.
So is your objection relevance?
Your Honor, it is.
And how would you respond to relevance?
Two responses. First, Your Honor, pre-trial stipulation number 2 already says that all of the exhibits are fair and accurate. So that was to their first statement. And number 2, it's relevant in establishing the relationship between Haywood Nelson, the offensive coordinator of the Cleveland Browns, and Fred Berry.
Your Honor, I'm not objecting to authenticity. I'm objecting to the relevance of a high school photo.
Okay, if your only objection is relevance, it appears that opposing counsel intends to use this to establish a relationship between the two pictures, which I'm going to say probably meets the bar of relevance. So overruled, and let's try to keep objections limited to the legal objection, legal responses.
What did you find when you searched Facebook?
Again, I found this photograph of, as stated, a young Freddie Berry and a young Haywood Nelson.
And
Objection, Your Honor, this is not in evidence.
And for the record, may it reflect that Exhibit 4 has been admitted into evidence.
may I publish it to the jury?
You may.
What did you find once you were on Facebook?
To reiterate for the third time, I found a photo containing young Fred Berry and young Haywood Nelson together.
And when you found this Facebook post, what was your impression? What did it tell you about the course of your investigation?
It told me that they knew each other for quite a while, considering it is, an old photograph specifically about the class of '89 of high school, which most of them have attended.
Once you watched the game and all of the in-game comments, and once you were able to search Facebook, what was the next step in your investigation?
So after establishing that the two individuals have some connection and might know each other, I decided to see if there's any communication between both parties, assuming that, you might keep in touch every once in a while with an old schoolmate.
And how did you look for any proof of any communications?
So at this step, what I did was I did two things. First thing is I called in a favor with a friend of mine at the telephone company to see if I could get any call logs.
And where does this friend work?
They work at Sprint.
Okay, Your Honor, at this time, I would like to approach the witness who has been pre-marked as Exhibit 5.
Okay.
On page 45 of the record. I'll switch with you. Without getting into the contents of this document, what is it?
It is it depicts a call log from the Sprint company.
And one more time, how did you receive it?
I called in a favor from a friend who was employed at Sprint.
And is this friend someone who would usually be the custodian of this type of record?
I believe so.
And is this a true and correct copy of the document that you received from your friend who works at the Sprint store?
It is.
And is it a fair and accurate copy of the record that you received?
It is.
Your Honor, at this time, I move to publish Exhibit 5 into evidence, tender to opposing counsel, and publish to the jury.
Okay, so on your first request to admit this, are there any objections?
Yes, Your Honor, this is hearsay within hearsay from Sprint to the unnamed friend to Mr. Thomas.
So
Objection, Your Honor.
the objection is hearsay and hearsay within hearsay. Let's constructively approach. And Counselor, tell me what your exceptions are to the rule of hearsay.
First, Your Honor, this individual is the individual who works at the Sprint store is somebody who is a custodian of the record. And may I please consult the pre-trial stipulations together? Thank you.
Your Honor, I don't believe that person has been.
Well, hold on, let's let her finish her response.
Your Honor, first, the actual record from the phone company meets the business records exception. Once we're able to lay the foundation for that. And two, pre-trial stipulation number 7 corrects the hearsay within hearsay issue.
Okay, so I heard what I thought was an attempt to lay a business records exception already, and we can address that in a moment. What stipulation are you pointing me towards?
Stipulation number 7, the phone number 202-867-5309 under the name Haywood Inn in the call log is authentic and verified as belonging to Haywood Nelson.
Okay, well, that would seem to authenticate the document, but it doesn't get around a level of hearsay. So do you have a second exception to hearsay?
Yes, Your Honor, may I conference with my counsel?
Of course.
Your Honor, on top of authenticating this as a business record exception to hearsay, we are also admitting this to show the effect on the listener, witness Thomas, who was looking at this document in the course of his investigation.
Okay. I heard the witness's testimony as to the business record exception and specifically the response to, is the unnamed friend a custodian of record? Not in those terms, but that's what the question was. And their response was, I believe so, or I think so. So I disagree that this is a business record that's been proven up. And to the extent this person is an expert, they can rely on this, but it's not necessarily admissible just because they relied on it. So feel free to lay another exception or relay an exception if you believe you have already, but for the time being, I'm going to sustain the hearsay objections.
So far you've taken 3 steps in your investigation. You've looked at the video clips, you've searched through Facebook, and you've looked through call logs. What was the 4th next step in your investigation?
It's not only the call logs that I received, I also did a second thing on my 3rd step, which was to contact the NFL directly and request a screenshot of Haywood's cell phone, specifically around text messages that he received at the time of the game.
Your Honor, at this time, I would like to approach the witness with what has been pre-marked as Exhibit 6.
Okay.
Without getting into the contents of this document, what are you looking at?
I am looking at a screenshot of Fred. I'm looking at a screenshot of Mr. Haywood's cell phone.
And how did you come into possession of that document?
I requested it directly from the NFL, which employs Mr. Hippard.
Did you receive it directly from the NFL?
Yes,
Is this a true and correct copy of what you received from the NFL?
yes, it is.
Is this a fair and accurate copy of what you received from the NFL?
Yes, it is.
Your Honor, at this time, I move to publish Exhibit 6 to the jury and admit into evidence.
Let's not show the exhibit to anybody just yet. Any objections?
Yes, Your Honor, can we approach for these?
Sure.
Judge, I'm objecting to hearsay if this comes from the NFL, and I'm going to object to hearsay within hearsay if there are any texts in this document from Haywood Nelson, who's not a part of here.
Okay.
May I respond, Your Honor?
Yes, respond to the initial hearsay objection, then we'll get to hearsay within hearsay in a moment.
Your Honor, these are an exception to the hearsay rule because they are opposing party statements. And if necessary, we are able to offer constructively redacting any responses from Haywood Nelson.
Okay. So let's say that we constructively redact any statements from Haywood Nelson. Counselor, does that resolve your hearsay objections?
To me, it does not, Your Honor.
And why is that?
Well, Your Honor, I don't have any kind of accompanying affidavit from the NFL that they.
Well, let me just stop you. Do you dispute that these statements that would not be redacted are the statements of Fred Berry?
As to any statements by Fred Berry, Your Honor, I don't believe those would be objectionable. My objection is to the entire document from the NFL and then anything from Haywood Nelson.
No, there's no need. I'm going to overrule the objection and we'll constructively redact any statements that are not from Fred Berry, which based on my understanding of iPhones, we're going to redact what would be the blue text messages.
Yes, and pre-trial stipulation 6 says so.
Okay.
Looking at the text messages that you have in front of you, does Mr. Berry send any text messages on Football Sunday?
Yes, he does.
What's the first message that Mr. Berry sends?
It says, "Are you ready for the game?"
And what time does he send that message?
This was at 12 p.m. on Sunday, November 15th.
Does Mr. Berry send any other messages on Football Sunday?
Yes, he does.
What's the next message that he sends?
The next message he sent was, "He's got to get in the game."
And what time was that?
This was at 1:45 p.m.
What is the next, and is there another message after that?
Yes, there is one more.
And what does that message state?
It says, "Tell him to stop. That's enough."
What time was that message sent?
This is at 3:30 p.m.
Looking at that message, I want you to focus on that last message. What is different about that message grammatically or stylistically from the other two messages that Mr. Berry sends?
Objection as to improper opinion.
May I respond, Your Honor?
Well, Counselor, do you think a reasonable lay person could tell me what the grammatical differences are between the text messages?
I do, Your Honor.
Okay. Do you want to withdraw the objection?
I'll withdraw, Your Honor.
Okay, thank you. Continue.
I'll ask the question again, Mr. Thomas. Looking at that last message, can you tell me grammatically or stylistically what you noticed as a difference between that last message and the other messages from Mr. Berry?
Yes, the difference is that this last message, he does use a lot more uppercase letters, so like cap locks, and he also used exclamation points.
And what did that tell you while you were completing your investigation?
It told me that the message itself is urgent and he wanted to get it through.
Thank you. Your Honor, I also want to make sure that this has been admitted into evidence and there were still objections.
Yes, the record will reflect that Exhibit 6 has been.
What was the next step that you took in your investigation? After you looked through the call logs and then once you looked through the text messages?
Okay, so I guess my next step after this was to kind of, let me rephrase. My next step after this in my investigation was to go even deeper in terms of Just to go even deeper, well, let me get more specific.
Mr. Thomas, would you like to be able to have a seat so you can finish your testimony from there?
Yes.
Your Honor, may the witness please be able to have a seat.
Yes.
Mr. Thomas, what is a quid pro quo?
Informally, it's known as you scratch my back, I scratch yours.
So once you looked through the phone logs and through the text messages, what did you look for next?
I try to look for like an exchange of favors, so to speak, as a quid pro quo would be.
And did you find any exchange of favors?
Yes, I did. I did find something in that section.
What did you find without going too deep into it?
I found that after the post game of Mr. Berry has wired $64,000 to a bank account that's associated with Mr. Haywood.
All right, let's slow down a little bit. Your Honor, I'd like to approach the witness who has been pre-marked as Exhibit 8B and Exhibit 8A.
Okay.
Without getting into the contents of 8B, what are you looking at?
I'm looking at Mr. Fred Berry's financial statements.
And do you know what 8A is? Do you know what that exhibit is?
8A is from the notary public confirming that these are accurate.
And what does that tell you in the course of your investigation?
This told me that the financial statement itself should not be into question, as they are accurate and truly reflect the transactions that happened within his account.
How trustworthy do you consider this document?
I would trust it with my life.
Is this a true and correct copy of the document that you received when you requested the bank records?
Yes, it is.
And is this a fair and accurate copy of the document you received?
Yes, it is.
Your Honor, at this time, I move to publish Exhibit 8B into the record along with its authenticating record for 8A.
Okay, on the issue of admission, any objections?
Yes, Your Honor, as to hearsay.
Okay, counsel, let's approach and plaintiff's counsel, as I understand it, 8A, well, 8A appears to be a business record affidavit. Do you disagree with that?
I see that, Your Honor.
And so your objection is hearsay to 8B?
My objection is to hearsay under, yes, Your Honor.
For exhibit 8B?
Great.
How do you respond?
Your Honor, the 8B fits under the business record exception and 8A is authenticating that document and the foundation has been laid for Exhibit 8B.
You respond on those grounds, Your Honor?
Yes, sir.
This does not come under the business records exception because it does not conform to 902.11. I was not given a pretrial notice that they intended to offer this. And as required under 902.11, I should have been given notice.
You weren't given a copy of the business record affidavit.
Your Honor, I wasn't given a notice from opposing counsel in writing.
Were you given exhibits 8A and 8B prior to trial?
I believe I had them, Your Honor, under the local rules. I'm not sure if I'm supposed to say yes or no to that.
And were they pre-marked as exhibit 8A and exhibit 8B?
They were, Your Honor.
And were they pre-marked with page 48 of 69 of the record and page 49 of 69 of the record?
Your Honor, I had the documents. I was just not given them by opposing counsel.
Gotcha. I will assume that these documents were exchanged through the ordinary course of discovery. And based on that, I will also assume that you had fair notice that exhibits 8A and 8B were likely to be offered or attempted to be offered during trial. So I will overrule the objection. And exhibit 8B is admitted, although 8A will not be admitted because I don't think it's necessary.
Looking at the bank statement in front of you, what did you notice that stood out to you as important in the course of your investigation?
It was a transaction made on November 16th.
And what was that transaction?
It was a transfer of money of specifically $64,000 to a Cleveland bank account.
And what conclusion did you draw from this transaction?
I was able to,
Objection as to improper opinion. May we approach?
Yes.
Your Honor, this is a question that would be asked of an expert. However, this witness has not been qualified as an expert.
May I respond?
You may.
Your Honor, witness Thomas completed an investigation on behalf of the Hard Luck Casino. I am simply asking witness Thomas what the conclusions of his investigation were.
And Your Honor, on those grounds, may I respond briefly?
1 second before you do, and I apologize, my court reporter is a little slow today, but will you repeat your question for me?
Yes, I asked, and what did that transaction tell you in the course of your investigation?
Okay, and is this expert have expertise in financial transactions of this sort?
No, Your Honor, the witness testified earlier that they have 2 certifications in private investigation work, and they are simply, if the witness is allowed to continue, eliciting the explanation of the quid pro quo that they went looking for after they looked through the text messages.
Okay, now you may respond, please.
Your Honor, if this witness is going to be asked to offer conclusions and opinions as an expert, I would like the opportunity to voir dire the witness.
And what would you be voir diring on?
All the deficiencies in qualifications, training, experience, and expertise that would disallow this witness's opinions and conclusions.
But in what realm of expertise? Because it sounds like this is an issue for cross at the moment.
Well, Your Honor, if the witness is going to be giving opinions to the jury on matters of forensic bank accounting and even investigation, I think the witness should be qualified as an expert in investigation before they're allowed to do that.
May I briefly respond, Your Honor?
No, just because I don't think there's a need. I understand what you're saying, Counselor. It's well taken. I'm going to overrule the objection and ask that you get into that on cross if you'd like.
In the course of your investigation, what did that transaction tell you?
Yes, in the course of my investigation, this wire transfer of $64,000 to this Cleveland bank account showed me that there was some sort of, again, quid pro quo agreement that was mentioned as maybe the suspicious, Mr. Haywood would make this conclusion of the game, as I mentioned in my figure 1, and in return, he would get $64,000.
Your Honor, at this time, I move to preserve the demonstrative.
Okay, that can be preserved as defense demonstrative 2.
Your Honor, next, I would like the court to take judicial notice that the transaction has been authenticated in pretrial stipulations as a bank account belonging to Mr. Haywood Nelson.
This doesn't really sound like an issue to take judicial notice on, but is it agreed upon by the parties?
There's a stipulation as to this matter, Your Honor.
Okay, then I will constructively read that stipulation into the record.
Your Honor, at this time, I pass the witness.
Any cross-exam?
Yes, Your Honor, may I proceed?
Yes, sir.
Good afternoon, Mr. Thomas.
Hello.
Now, you're an employee of the Hard Luck Casino since 2018, right?
That is correct.
Sir, you collect a salary there, right?
That is correct.
And it's your job to investigate potential fraud, right?
That is correct.
You get that salary whether you're right or wrong on those fraud calls, though, don't you?
That is correct.
Now, sir, you get a bonus on top of this salary, right?
That is correct.
In fact, you get a bonus of 5% of any money the casino doesn't have to pay out for fraud, right?
That is correct.
Your Honor, may I approach the demonstrative?
Sure.
I'd like to jot down some things as we talk.
Not on their demonstrative.
Not on their demonstrative. Approach, thank you. Now, sir, you said you get 5% as a bonus
Yes, that was the standard.
on top of your salary.
Yes.
Okay. Now, in the last 3 years, you've made about $550,000 just in bonus money, haven't you?
Yes, sir. If the math adds up, yes.
That's a yes to my question?
Yes,
So $550,000 is the extra bonus money you've been getting for doing these kind of investigations, right?
that's true.
And sir, in this matter, there's about $980,000 at stake, right?
Yes, that is true.
Okay. So $980,000. You're gonna get 5% of that if you're right, aren't you?
That is true.
Or you're gonna get 5% if the casino wins its case, right?
Yes, 5%.
Do you happen to know offhand what 5% of that is?
No,
I bet you've already done the math on it, haven't you?
I will, you can go ahead and write it down.
All right, let me get a calculator just to save us both here.
Thank you.
Sir, 5% of $980,000 is $49,000. Does that sound correct to you?
Yes,
I just want to make sure I understand. You're going to make this much money if your employer wins this case.
yes, that is true.
Sir, I want to talk about the Browns Texans game on November 15th, 2020, okay?
Right.
Now, it's your contention that my client and Haywood Nelson manipulated that game, right?
Yes,
Okay. And they manipulated the game so that Nick Chubb would only score one touchdown, right?
yes,
So if Nick Chubb already scored his touchdown, the coach would pull him out of the game so that he doesn't score anymore, right?
Objection calls for speculation.
Because it's cross-exam, the witness can answer if they know.
Sir, I'll repeat my question. So if Nick Chubb has already scored his touchdown and they don't want him to score anymore, they're going to pull him out of the game, right?
I mean, not necessarily a coach or expert on NFL things, so I wouldn't know.
Okay. So it's your contention that Nick Chubb only went back into the game because the other running back got injured, right?
I wouldn't-
Objection calls for speculation.
Would you constructively approach, would you just repeat the question, please?
Yes, I asked him if it's his contention that Nick Chubb only went back into the game because the other running back got injured.
May I respond?
No, if it's his contention, it's his contention. So again, the witness can answer if they know.
Your Honor, the witness has never testified that the only reason Nick Chubb was in the game was because another player was injured.
Right, and if that's the case, I would suppose the answer would be no, because the question was whether it was his contention. But please do re-urge the objection if you think the testimony crosses any lines.
Is that your contention?
Could you repeat?
Yeah, sure, I'm sorry. Is it your contention that Nick Chubb went back into the game on Cleveland's 8th possession because Kareem Hunt, the other running back, got injured? That's not your contention.
No,
Have you ever testified differently?
I would like to be refreshed. If allowed.
Sir, it's a simple yes or no. Have you ever testified differently?
Objection asked and answered. He asked the question. The witness gave an answer.
I don't believe the witness did give an answer, but do feel free to re-urge the objection if you feel that they do answer and the question is asked again.
Sir, has it always been your testimony that Nick Chubb only went in because Cleveland's other running back, Kareem Hunt, was injured?
Yes,
Now, sir, you believe that this play that happened where Nick Chubb ran out of bounds you believe that he went out of bounds, even though there was no legitimate football reason to do that, right? And you believe that play was called by the offensive coordinator, right?
Yeah.
And you believe the offensive coordinator also had no legitimate football reason to call that play, right?
Yes,
Sir, you watched the Nick Chubb interview after the game, didn't you?
I did.
And in that interview, Nick Chubb gave a legitimate football reason for his play, didn't he?
I believe he, I quote, he was said he was instructed to not score.
Sir, is it your testimony he didn't explain his decision not to score at that time?
That was my answer. He was instructed to not.
I'm sorry, can you speak up a little bit?
My answer was that he was instructed to not score.
And sir, my question, after you said you watched the Nick Chubb interview, did Nick Chubb give a football reason for why he did what he did in that interview?
I mean, I guess you could say it is a football reason because his higher ups, his coach told him not to score.
At this time, Your Honor, I would like to display Exhibit 12, which is a video footage of Nick Chubb's interview. We seem to be at a discrepancy with what was actually said in the video.
Are you showing this to the witness only, or are you putting this into evidence? What are you asking for, counsel?
I'd like to offer it into evidence.
Okay. Is there any objection to what I believe was Exhibit 12?
Yes, it's improper impeachment. He's publishing something to the jury in attempts to impeach the witness, and he doesn't need to do that to impeach the witness.
I believe he's just offering it into evidence. Do you have an objection to the exhibit?
Yes, sir. One, they objected to hearsay when it was discussed earlier by the witness, and two, he's asking the witness whether the witness remembers comments. The witness is saying he doesn't. He's offering the exhibit now to impeach the witness.
Okay, let's constructively approach. As to Exhibit 12, regardless of circumstance, do you have an objection to it? Just a legal objection?
Yes, it's hearsay, Your Honor.
Okay, all right. And what's the response to the hearsay objection?
Your Honor, I only want to show the first 25 or so seconds. And in that 25 seconds, you're going to hear Nick Chubb, who's giving a post-game press interview. He's going to say that the coach told Baker Mayfield, the quarterback, to tell the offense not to score, run out the clock, and win the game. Now, this overcomes hearsay because from coach to quarterback, that's a command. Excuse me, that's a command. That's not an assertion. From quarterback to the offense, again, that's a command, not an assertion. And for Nick Chubb to talk about it, it just goes to show his state of mind, Your Honor, as to why he did the play.
May I respond?
Yes, please.
Your Honor, Nick Chubb is not testifying here before the court. He's also not able to be cross-examined. So even offering 25 seconds of hearsay is still hearsay.
I believe I just addressed the hearsay.
I'm not sure you did, Counselor, and that's my issue. So I'm going to sustain the objection, but do feel free to try again and lay a foundation for an exception.
Thank you, Your Honor. So, sir, it's your testimony that Nick Chubb had no legitimate football reason.
Well, as you just now mentioned, apparently the reason the question is because the coach told the quarterback who then told the offense to not score.
And the coach who said to win the game, right?
By your statement.
You didn't see the video, sir,
I did.
and you don't recall him saying he did it to win the game.
Your Honor, objection, hearsay. What the opposing counsel is trying to admit a statement, an out-of-court statement for the truth of the matter asserted.
Your Honor,
No, it's okay. Let's constructively approach and have a very brief response.
Your Honor, this objection was just waived because the witness went into the hearsay statement as well, and we've already had 2 or 3 questions about it. So this is not a timely objection. The door's been open and the jury's heard.
May I briefly respond?
Yes.
Your Honor, the witness is not the one who's opening the door. The witness is being asked leading questions to leave the door open by opposing counsel. Opposing counsel has already attempted to admit Exhibit 12 into evidence. That has been overruled. Leading the witness to open the door is not the witness opening the door.
May I respond to that?
No, counsel, while I appreciate what you're saying, he's asking leading questions on cross-exam, which is standard, and he's laying a foundation, which is also standard. That being said, I don't think you've laid the foundation yet, so I'm going to sustain the objection, but do feel free to lay your foundation and try to re-enter the exhibit.
Sir, you wrote a report in this matter, didn't you?
Yes,
And one of the things you relied on in your report was viewing the interview that Nick Chubb gave after the game. Right?
yes, that's what is for springboarded investigation.
That springboarded the investigation, and some of the words that Nick Chubb said in that interview are crucial to your findings in this case, right?
They definitely did, as I mentioned earlier, springboard the investigation, but it was more so, a lot more of the facts that were discovered because of his statements.
And central to your case as the casino is that Nick Chubb had no legitimate football reason for the play he did. Right?
From my perspective and from my feelings, yes.
Your Honor, may we approach? Okay. Your Honor, I believe we have laid the foundation. This witness is denying that there's a legitimate football reason. The interview is going to contradict that. If we don't publish it to the jury, Your Honor, can we show it to the witness so that at least he can see the part of the interview that we're.
No, I understand, counsel. So I assume there's still an objection.
Yes, there's still a hearsay objection. One, just because the witness relied on a video does not make it admissible, and that's not an exception. Reliance is not an exception to hearsay. Number two, the witness has been continuously asked what they relied on, and the witness has said they relied on the statement. Their coach told them to do something, and that's been their answer continuously.
What I understood right now is that it's being offered to contradict the witness, and for those purposes, I'm going to allow it, and we can admit Exhibit 12. So I'll overrule the objection, but I will give a limiting instruction to the jury that they are only to consider this exhibit to the extent it contradicts this witness's testimony.
Thank you, Your Honor. And just to be clear, the testimony we're contradicting is him saying there's no legitimate football reason to call the play.
Correct. And that will be part of the limiting instruction given to the jury.
Thank you, Your Honor. Could we play the first 25 seconds of Exhibit 12?
Does the video have audio? I know I don't think, I mean, hold on, let me see if I can. Does it have audio?
I don't know.
Yeah, the video.
Okay, so hold on.
Hear it though.
Hold on 1 minute.
Okay, you can continue.
Sir, did you hear him say he was told not to score, to get a first down and to end the game?
Yes, I was able to hear the video, yes.
So wouldn't you agree that ending the game with a win is a legitimate football reason?
Your Honor, objection. The witness is not an expert on football. They can't attest to what is a legitimate reason or not.
Response briefly?
I think we're already past that point, Your Honor.
Well, I'm not sure that that's a response to the objection, so I'll sustain it for the moment, but if you'd like to try again.
Sir, winning a game is a legitimate football motive, right?
Thank you.
Sir, let's talk about your background just briefly. Now, you created a report in this matter, right?
That is true.
You didn't rely on any depositions taken in this case,
I did not.
and you didn't rely on any answers to interrogatories in this case.
Could you specify as to whose interrogatories I would use?
So
Hypothetically?
you didn't use any of them, did you?
No.
And sir, you didn't rely on the pleadings in this case.
No,
You didn't conduct any interviews with my client.
I did not.
You didn't conduct any interviews with Haywood Nelson.
Someone's investigating. No, I did not.
You didn't conduct any interviews with anybody else that was in the press box with Haywood Nelson, November 15, 2020. Sir, interviewing is an important part of investigation.
I'm pretty sure if any reasonable person was to be investigated for fraud, I think if they were knowing that they were being investigated, it would change their behavior.
So the answer to my question is no, interviews are not important to investigations.
And my answer is no, I did not interview anyone.
Now, sir, you were a police officer over 20 years ago, right?
That's true.
And since then, you've been a bouncer.
That is true.
You've been a security worker at casinos.
That is true.
You even ran the books for a little while,
That is true.
financial books.
That is true.
And you've been an investigator only here since 2018.
Yes, which is 3 years, which is, if I was bad at my job, wouldn't I have been fired by now?
Objection to non-responsive.
Any response?
Your Honor, the witness answered the question. Yes, he's been employed and then offered an explanation. He's good at it. He's been there for 3 years. So his first statement was the answer.
Well, his first statement was the answer. The second part was not. So I'll sustain the objection as to the wouldn't I have been fired if I wasn't. Strike that from the record and instruct the jury to disregard.
Sir, as we sit here today, you're still on their payroll, aren't you?
That is correct.
Ask the witness.
Any redirect?
Briefly. Looking at this demonstrative here, this $49,000, have you been paid a bonus yet?
I have not.
No further questions, pass the witness.
I don't believe I allow recross in my court plaintiff's counsel, so I apologize. I'm going to let the witness step down, be excused if he wishes.
Thank you, Your Honor.
Defense, do you have any additional witnesses?
No, Your Honor, at this time.
Okay, great. Before plaintiff opens their case in chief, is there anything that you'd like me to kick the jury out and address with the court?
There is, Your Honor. I have several motions to be taken up outside the presence of the jury.
All right, jury is constructively told to go get lunch. Let's hear the motions.
Your Honor, first of all, I believe we're entitled to a judgment as a matter of law on the issue of intent to cheat, Your Honor, as a crucial part of the fraud claims. There's been no evidence by which a reasonable juror could adduce that there has been an intent by my client to cheat.
Can you counsel? It's just to the intent element. Is that what I'm hearing?
Yes, Your Honor, 465.070. I'm looking at number 5.
Yeah, so what is the response to the directed verdict as to the necessary element of intent?
Your Honor, we have elicited testimony that Fred Berry on November 13th called his friend and then subsequently placed a bet of hundreds of thousands of dollars. The standard for judgment as a matter of law is that no reasonable juror could draw the conclusion. I do think we've laid sufficient evidence that a reasonable juror could draw intent from the evidence we elicited at this time.
Which evidence is that?
That Mr. Berry placed a phone call, placed a very large bet, and during the game was texting instructions that would win his bets.
I don't believe the phone call came in though.
Well, I'm sorry, Your Honor, the text messages.
Okay. Do you have any other parts of your motion, plaintiff?
I do, Your Honor. As to the issues of conspiracy and irregularities, Your Honor, I asked for a judgment as a matter of law on those matters. No directed verdict, Washingtonian State Court. Because, Your Honor, these issues were not pled in the defense's affirmative defense pleadings. And that's on page 14 of the record.
Which elements are you referencing?
Conspiracy to commit fraud and the creation of irregularities. That's not in here in these pleadings.
Okay, and how do you respond to the that portion of the motion?
Your Honor, our affirmative defense under the appropriate Washingtonian state statute applies to both the conspiracy to commit fraud, committing fraud, and creating irregularities. And as such, we have pled both of them.
Which statute was that?
I'm gonna let counsel take over for me. Let's step out.
Under Washingtonian statute 465.70 for fraudulent acts, and then 465.70 on page 14 of the record, the plea only looks for wagers that were made knowingly and intentionally fraudulent. And so our position is that there are several ways that can commit fraud, all of which should be presented to the jury. We only need to prove one of them to establish fraud.
Right, in my contention, Mr. Your Honor, if I may.
Plaintiff's counsel did we include that statute in our jury charge after our pretrial conference?
Your Honor, it's in the jury charge. My contention is that it should have been in the pleadings.
So the statute though is what, oh, yep, found it.
There was a correction on page 14 of the record. Paragraph 19 should say 465.072, talking about the remedies. So that leaves the pleadings without any reference to 465.070 and 071, I'm sorry, that's the conspiracy statute.
Yeah, interesting motion, well taken, denied though.
And finally, Your Honor, on the issue of knowingly and intentionally made a false and important representation to the defendant, there's been simply no evidence that my client made representations to the casino. There's been no evidence of an interview with my client, a discussion, a conversation, anything in writing from my client. So, Your Honor, I believe on paragraph 20, we'd be entitled to a judgment as a matter of law. There's just simply no nail to hang a hat on for that.
Your Honor, may I respond? Your Honor, Exhibit 3 established the rules that are printed on the back of every ticket. Fred Berry intentionally made a misrepresentation when he placed his bet, knowing that he was going to be relying on his relationship with Haywood Nelson in order to secure a winning bet. So Exhibit 3, by agreeing to this contract, by placing a bet with the casino in exchange for winnings if he were to win his wager, is the misrepresentation. And that's Exhibit 3 has already been published to the jury so they can make that determination themselves.
But I don't believe that contains any representation on the part of my client to the casino.
I understand what's being argued in the response and I agree. So the motion is denied.
That was it for plaintiff, Your Honor.
Okay, great. We are running a little behind the clock, which is never the court's fault. Now, that being said, if anyone needs a bathroom break, we can take one very quickly. I would just ask that we try to get back to it as soon as possible.
3 minutes here.
How are we looking on time?
We're off the record. the full panel of judges come back. We ready to go?
Good to go.
Which one was it?
That was just a second. What's the other?
Is Judge Bennett back?
That is still on the call.
He's still on the call. Judge Bennett, have you
It's in the chat.
returned? Send him a text.
The record. The bench just rested their case in chief. Plaintiff, would you like to put on a case?
We would, Your Honor.
Okay, feel free to call your first witness.
Your Honor, the plaintiff calls Fred Berry to stand.
Mr. Barry, you're still under oath. Is that?
Yes, sir.
Proceed whenever you're ready.
Thank you, Your Honor. Good afternoon. Could you please introduce yourself to the jury?
Hello, my name is Fred Berry.
Mr. Berry, what do you do for a living?
I'm an investor, philanthropist, and a stock trader.
What are you here about today?
I'm here because I'm suing the Hard Luck Casino for failing to pay me on the bets that I had won.
Let's talk about these bets. What were they for?
There were two bets on the Houston Texans versus Cleveland Browns football game that took place on November 15th, 2020.
Okay, and when did you actually place the bets?
I actually placed the bets 2 days before on November 13th, 2020.
What specifically did you bet on?
So I placed one bet on the outcome of the game, as well as a proposition bet on one of the players' performance. I bet about $230,000 on the outcome of the game, as well as $86,000 on the proposition bet.
Why did you bet on the game?
So I bet on the game because I saw an opportunity. The line had basically moved from 3 to 3.5, which meant if you had bet on the Texans winning the game or losing by more than 3.5 points, you would win the bet. And that half point's important because now a field goal means your bet is still safe.
Okay, so what was the outcome of that bet?
Well, the outcome of that bet was that I won. The Texans had lost, but it was only by 3 points, a field goal, which means that my bet was safe and I still won.
What was the final score?
Final score was 10-7.
Now you said you made two bets. What was the second bet?
That second bet is a proposition bet. That's on the performance of Nick Chubb. I had made a bet that he would score exactly 1 touchdown.
Okay, and how much did you bet?
That one was, I believe, 86,000.
What did you stand to win on the 86 if you won it?
On the 86, I believe it was a little over $400,000 would be the payout on that one.
Okay. What came of that bet?
I actually won that bet because Nick Chubb had scored 1 touchdown.
Do you know whether your bets were placed on time?
Yes, they were placed timely.
Did you go try and cash in your bets?
I did, I believe on the 19th, I went to go cash in on the bets, and the casino refused to cash them.
What happened after the casino refused to pay your bets?
Well, after they refused to pay my bets, I said, I decided to proceed with the lawsuit. They owed me that money, and so I was going to sue them.
So including the money you put in and the money you won, how much of your money does the casino have right now?
The casino's withholding a little bit under $1 million from me.
Okay, let's talk about your relationship to Haywood Nelson. So we're going to change gears a little bit. Have you been sitting here throughout this trial?
I have, yes.
Have you heard the casino make this allegation about communication, improper communication between you and Haywood Nelson?
I have heard that, yes.
What is your response to that?
That's not true. Haywood Nelson and I have been friends for a long time since school. We keep in touch with each other every now and then, but none of our communication is regarding my bets or anything like that.
Did you hear testimony regarding a bank transaction?
I did hear about that, yes.
What was this bank transaction you made to Mr. Nelson the day after the football games?
It was a contribution to a fundraiser that I had seen about on Facebook by Haywood Nelson. It was a fundraiser for our old high school, our alma mater, to try and get some new gym equipment. And I wanted to contribute to that.
So you said a Facebook post. Do you recall when you saw a post on Facebook about this?
I believe I had seen it on November 11th.
I am, Your Honor, I'd like to approach the witness with what's been pre-marked as Exhibit 7.
You may do so.
And I'm showing to opposing counsel. Mr. Berry, without going into the contents, well, first of all, let me ask you this. Do you recognize this?
I do, yes.
And without telling us what's in it, what is this exhibit?
This is that Facebook post along with a picture that I saw.
Is this a true and correct copy of the Facebook post that you saw?
It is, yes.
And is the picture in it a fair and accurate representation of the picture that you saw?
Yes, it is.
All right, this time I offer Exhibit 7. Any objections?
Yes, Your Honor, as to the offering and publishing of the Facebook post itself, it is hearsay. And I believe it is cumulative or improper bolstering. There's no reason for him to have to admit the Facebook post into that.
Okay, well, let's take up the hearsay part. What's the response?
Your Honor, I'm not offering this for the truth of the matter. I'm offering it to show the effect on Mr. Berry from after he saw it.
Last word?
Yes, Your Honor, again, he is offering it to show that there was a fundraiser announcement. So he is offering it for the truth of the matter asserted. And again, it is irrelevant. He already asked about the fundraiser. There's no need to publish this Facebook post after he just went through that whole.
So is the objection relevant or what?
It's hearsay and relevance.
Okay, so how about the relevance ground? Why is this relevant? And we'll constructively approach and you can briefly tell me.
Your Honor, Mr. Berry is being accused of transferring $64,000 to Haywood Nelson as a payoff for a sports bet, when in fact it was done for a fundraiser. So this makes it more or less likely it's probative as to why he sent him that money, and it's a material issue in this trial, Your Honor.
Okay, well, you've now made conflicting representations to the court that one, you're not offering this for the truth of the matter asserted that there is a fundraiser, and two, that he in fact made a donation to a fundraiser. So which is it?
Your Honor, he believes it was for a fundraiser, and I'm showing that he made the donation for what he thought was a fundraiser.
Gotcha. I'm going to overrule the objection and I'll give a limiting instruction to the jury that this is not being offered as evidence of a fundraiser, but only of evidence that this person believed there was a fundraiser.
This was Exhibit 7 admitted.
It is with that limiting instruction, which I'll now constructively give the jury.
Thank you, Your Honor. So Mr. Berry, what happened when you saw this Facebook post?
So when I saw this Facebook post, I had actually spoken to Haywood Nelson about it and about making a contribution to it.
What did you do next?
After I made that phone call, I eventually transferred the money over that following Monday.
Okay. Your Honor, I pass the witness.
Okay, cross-exam.
Proceed.
Next.
Mr. Berry, you called Haywood Nelson on the morning of November 13th, right?
Yes,
During that phone call, you offered to donate to his charity $64,000.
yes, we talked about the fundraiser.
Later that day, you walked into the Hard Luck Casino and placed 2 bets.
I don't remember if it was after the phone call. I just remember it was the same thing, but I don't remember if it was after.
And one of those bets was for $230,000,
Yes,
and the other one was for $86,000.
yes,
In total, you put down $316,000 on November 13th.
pretty quick with math, so yes.
This number, $316,000. It's more than you normally bet, right?
Yes, this was a huge opportunity.
I bet it was, because you normally bet about between $5,000 and $10,000 at a time, right?
Yes, the casino or the Hard Luck Casino flinched and I took advantage of that.
The biggest bet you'd ever made in your life was $27,000.
Yes, I was waiting for an opportunity like this.
This bet is more than 10 times the normal amount of money. I'm sorry, the biggest bet you'd ever made in your life.
Yes, this was the biggest bet.
Now, you have a method when you bet, don't you?
Yes,
And I want to make sure I get this right. It's important to be patient.
yes, very.
You wait for an advantage
Yep.
and you hit it hard.
Yes, it's like a game of poker. You don't go all in every hand. You wait till the opportunity presents itself and then you go all in.
And to be clear, you normally bet about $20,000 a month.
Yes, I said that already.
Well, no, you didn't say that. You didn't say you normally bet $20,000 a month. So is that a yes to my question?
Yeah, my bets tend to be around 20,000 a month, sure.
So that means you bet about $240,000 a year usually, right?
Yes, that's how the math works.
So that bet that you looked for an opportunity for and hit hard was more than you usually bet in a year.
Yes, like I said, the opportunity presented itself.
I'm sorry, you said opportunity presented itself? Did I hear that correctly?
Yes, the casino flinched. They moved the line from 3 to 3.5, and I took advantage.
Now let's move to November 15th. That's the day of the game, right?
Yes, November 15th was the game.
You communicated with Haywood Nelson that day too, didn't you?
Yes. I sent him a good luck text that day.
You sent them more than a good luck text, didn't you?
I believe I just talked about the game with him.
Yeah, the permission to publish what has been already admitted as Exhibit 6 to the jury.
Has Exhibit 6 been admitted? Do we all agree on that?
Your Honor, it has subject to the redactions of anything that Hayward Nelson said.
I knew there was something about it. So as redacted, yes, sir, we can publish that. Constructively redacted.
So, Mr. Barry, correct me if I'm reading this wrong here. On Sunday, November 15th,
I object, Your Honor. May we approach? There's multiple exhibits, multiple items on the screen here.
Okay, we'll constructively, that's not there.
Okay.
now, correct me if I'm reading this wrong. On Sunday, November 15th at 1:45 PM, that message from you says he's got to get in the game.
Yes, I sent that.
Okay. Now, one of your bets was for Nick Chubb to score 1 touchdown.
I was, yes.
And that bet was for him to score exactly 1 touchdown, right?
Yes.
So this next text message, tell him to stop. That's enough. You said that one too, right?
Yeah, you read that correctly.
Okay, and you needed Nick Chubb to score exactly 1 touchdown, right?
I believe you asked that already, yes.
You also say that's enough, right?
Yeah, it says that.
Now, I want to talk a bit about your bet because that game ended 10-7.
Yes, it did.
If Cleveland had scored 1 more point, you would have lost that bet.
Yes, I would have. Assuming that the Texans didn't score again.
And if Nick Chubb would have scored another touchdown, you would have lost your bet on him too.
Yes, if Nick Chubb had scored again, I would have lost the bet.
And that bet, again, you would have lost $316,000.
Assuming the Texans weren't able to score again after the Cleveland possession.
No further questions, John. Pass the witness. Time to preserve the demonstration. D3, D4. D next number.
It will be preserved as what I believe is defense demonstrative 3, but if I'm wrong, it'll be defense demonstrative 4. Any redirect?
No redirect, Your Honor.
Okay, can Mr. Barry probably just step down from the stand?
That's fine with me, Your Honor.
Thank you, Mr. Barry.
Your Honor, this time plaintiff calls Haywood Nelson.
That's me.
Okay, we'll step down and then get back. I'm just, all right, Mr. Nelson, you remain under oath.
Yes.
Good afternoon, Mr. Nelson. Could you introduce yourself to the jury, please?
Hello, my name is Haywood Nelson.
And what do you do for a living, sir?
I'm the offensive coordinator for the Cleveland Browns.
How long have you been in coaching positions in football?
I've been in the NFL for quite a while now. I've coached with the Atlanta Falcons before I eventually became the offensive coordinator for the Cleveland Browns.
All right, let's talk about why you're here today. What is your relationship to my client, Fred Berry?
Fred Berry and I, we went to the same school together. We've stayed in touch every now and then. So we're friends.
Now, sir, I'm just going to cut right to it. Are you aware there's been some allegations made in this matter?
I am aware of that, yes.
Are you aware that there's been an allegation of fraud against Mr. Berry?
Yes.
And are you aware there's been an allegation that alleges that you conspired with him to commit fraud?
Yes, I'm aware.
And what's your response to that?
That it's not true. I wouldn't risk my entire career on something like a sports bet for Fred.
What discussions have you and Fred Berry had regarding his bets?
But we don't talk about his bets.
Okay. I want to talk about this game on November the 15th, 2020. Do you remember that game?
I do. That was against the Texans.
Do you remember the outcome of the game?
Yes, we had won 10-7.
Are you familiar with a play where Nick Chubb broke loose near the end of the game and then stepped out of bounds?
Yes, I am aware of that. Yes.
Okay. Well, I'll just ask you right out. Who called that play?
That was a play that we called. It was our goal to win the game, and that's what we believe we needed to do to win that game.
Okay, what was the play call exactly? Let's walk through this.
Essentially, the play call was to get a first down, run the clock out. We had the lead, we had the ball, there were no timeouts. And so if we just held on to the ball, we could run the clock out, win the game.
Okay, so explain this to me like I'm not an NFL coach. Why would you tell a player not to score near the end of the game?
So since we have possession of the ball, we get to control the pace of the game. If we had scored a touchdown, the ball would go back to the Texans, give them an opportunity to score. And then after that would give them the opportunity to kick an onside kick, try and retain possession and score again. If we had allowed that touchdown to go forward, the ball would be in the Texans' hands and they would control the tempo there.
Okay, so you give this instruction and then did the players follow the instructions?
Mostly. We didn't score, which is what the instruction was. Nick Chubb did step out of bounds, which stopped the clock. However, we were able to take a couple knees and run the clock out and secure the victory.
Would it aid the jury in understanding your testimony if we put up a picture of that moment just so you can describe a couple things for us?
Yes.
Your Honor, may I set up a demonstrative of that moment where Nick Chubb ran out of bounds?
You may.
Now, Mr. Nelson, who is this right here?
But that would be Nick Chubb, the running back.
And what is he doing right here?
That's when he stepped out of bounds.
What happened when he stepped out of bounds?
So when he stepped out of bounds, that prevented us from scoring, which was what the goal was. However, it did stop the clock under a minute. So we did have to take some knees to keep the clock going and win the game.
What do you want the clock to do when you're in this position?
You want the clock to hit 00. You want the game to be over and that score to stand. So that was the plan.
So when Nick Chubb is right here, what else are his options?
He could have taken a knee, could have slid, could have just ran along the end zone. Anything except scoring would have been a proper thing to do.
So you said slid. What happens if he slides down like right before the end zone?
If he goes down inbounds, the clock continues to run. That lets the offense set up again. And if we need to, we could take one more knee and make sure that clock hits 00.
So you said something about taking a knee to end the game. What does that mean? What does that look like?
So taking a knee, essentially, the person who has the ball just goes down and makes sure their knee touches the field. Make sure it hits the floor of the field. That way, if the clock continues to run, it doesn't stop, ensuring that we win the game.
Mr. Nelson, who won the game?
Well, we did, the Browns.
Pass the witness.
Cross exam.
May I proceed?
You may.
Mr. Nelson, you're prohibited from using your phone when you're in the press box, correct?
Yes, that's one of the rules.
But you had your phone with you on November 15th.
I did have it with me, yes.
And so you had your phone with you during the Houston Texans Cleveland Browns game.
Yes, it was with me.
You could have put your phone in your locker,
It is something I could have done.
but you didn't.
No, I had forgotten it was in my pocket.
You didn't know until the phone fell out of your pocket?
Yes, like I said, I had forgotten. And when we were celebrating at the end of the game, it had fallen out of my pocket and that reminded me.
So you had your phone with you. You can't guarantee that your phone was off, can you?
I'm sure it was off or silent. I can't tell you which one it was, but I know it was one of the two.
Can you answer the question with a yes or no? You can't guarantee that your phone was off.
I think I said yes to that.
Yes, you can guarantee, or no, you cannot guarantee.
I can't guarantee that it was off. I just know it was either off or silent.
Even though NFL protocol requires you to have the phone off or in a locker.
That is what the protocol is. I had forgotten it was in my pocket.
So as you sit here testifying today, you can't guarantee that you are following NFL protocol on the game in question?
I had forgotten the phone was in my pocket, so
Sorry, can you answer with a direct yes or no? You can't guarantee that you are following NFL protocol on the game in question?
Objection, Your Honor, may we approach?
Okay.
Objection to relevance.
How would you respond to the relevance objection?
Your Honor, it's relevant whether the individual had his phone in his possession because because Fred Berry is being accused of conspiring with Haywood Nelson by sending text message instructions back and forth.
Yeah, I agree. Overruled.
I want to make sure the jury heard that last question. On the game in question on November 15th between the Houston Texans and Cleveland Browns, you cannot guarantee that you are following NFL protocol.
no, I can't guarantee it.
I want to switch to the phone conversation that you had with Mr. Berry. You did talk to him at 10:15 in the morning on Friday, November 13th.
Yes,
And during that phone call, you told him that you were happy to have Nick Chubb back in the game,
I may have said something about that.
even if on a limited basis.
Again, I may have said something like that.
Other players at the Hard Luck Casino wouldn't have heard you say that to them.
Objection calls for speculation.
Response, constructively approached response.
Yes, Your Honor. One of the elements of the case against Mr. Fred Berry is that he has inside information that other individuals do not have. It is relevant whether Haywood Nelson shared that information with anybody else, and he did share it with Fred Berry.
I believe the objection was speculation, not relevance.
Your Honor, it's not speculation for Mr. Nelson to admit that he only had a conversation with one person.
Last word.
I believe the question asked him if other people overheard a conversation.
I am going to sustain the objection to the extent it does call for speculation, but do feel free to ask it differently.
You did tell Fred Berry that you were happy to have Nick Chubb back in the game.
I may have mentioned something about the game, yes.
Not about the game, that you were happy to have Nick Chubb back in the game,
Yes, I may.
even if on a limited basis.
Objection asked and answered.
I believe council's just circling back. So on a limited basis, I'm going to overrule, but please do. Move on.
I want to talk to you briefly about the fundraiser that you mentioned that you started. You started that fundraiser in November 2020,
So what was the date, sorry?
November 2020,
Yes, November 2020.
about 2 years ago.
I believe it's 2021, so it would have been 2020 or 1 year ago.
Your goal was to raise $100,000.
That was the goal, yes.
As of December 2020, the fundraiser raised $64,200.
Yes,
How much of that $64,200 was from Fred Berry?
64,000.
And Fred Berry donated that money to you on November 16th, 2020,
I believe so that Monday.
the very next day after the game.
Yes.
Watts High School didn't authorize a fundraiser.
No, I didn't seek authorization from the high school.
And as of March 2021, Watts High School hasn't received any money from you for a fundraiser.
No, I'm waiting to hit the $100,000 mark so we can renovate the gym.
And you gave Nick Chubb the instructions not to score?
The offense, including Nick Chubb, yes.
I want to revisit this briefly. After your conversation, or you had a conversation with Fred Berry about Nick Chubb being back even on a limited basis.
I believe that misstates the testimony, Your Honor. Objection.
Your Honor,
Yes.
the witness answered yes to both of those questions. Both, yes, they had a conversation about Nick Chubb being back in the game, and yes, even if on a limited basis.
I understood him to say he may have.
Counsel, let's not have any crosstalk.
Apologize.
Re-ask the question and the witness can answer, yes, that was my testimony, or no, that was not my testimony. And after the answer, if you feel the witness was incorrect, feel free to take that up on redirect.
You gave the instruction for Nick Chubb, or sorry, let me revisit that. You told Fred Berry that you were happy to have Nick Chubb back.
Like I said, I may have.
Do you remember testifying differently?
I honestly don't remember.
Do you remember giving a deposition in this case?
I believe it was, yes, either a deposition or interrogatories. I'm having a little bit of memory trouble, sorry.
Do you remember being given the opportunity to review your statements?
Yes,
Do you remember being given the opportunity to change any statements?
yes,
Do you remember affixing your signature to your deposition?
yes.
Your Honor, may I approach the witness with a section of their deposition on page 29 of the record?
Could I have the line number?
Yes, line 38 to 41. Oh, sorry. Your Honor, may I have a brief moment?
Of course.
I apologize, Your Honor. Page 28 of the record, lines 40 through 43. Can you follow along with me while I read out loud? You were asked the question, did Fred Berry ask you about the health of Nick Chubb in a conversation you had the Friday before the Cleveland-Houston game? Answer, I do not recall asking him, but I may have said something about being happy to have him back in the fold, even if on a limited basis.
Like I said, I may have said that.
Objection to improper impeachment.
I do not believe counsel has impeached the witness just yet. So a little premature, but if you feel like she gets there, feel free to reurge the objection.
Well, Your Honor, may I be heard? Counsel did not read.
How about we approach and you may now briefly tell me what you need to tell me.
Your Honor, counsel did not read word for word, starting at line 42.
May I respond, Your Honor?
Why don't we let plaintiff's counsel tell us what the reading error was first?
Your Honor, what I heard counsel say was, I do not recall asking him. And it says, I do not recall him asking.
Okay. Would you like to reread that part of the sentence just so that the record is clear and correct?
Answer, I do not recall him asking, but I may have said something about being happy to have him back in the fold, even if on a limited basis.
Yes, that's what I said.
So on the Friday before he placed his bet, the conversation wasn't just about the fundraiser.
I don't know when he placed his bets.
On the Friday morning that you spoke to him, the conversation wasn't just about the fundraiser.
Like I said, I may have. I'm not sure. I don't remember him asking about the game or anything like that.
Are you still not sure about having a conversation with him related to football on the morning of November 13th?
Objection as to argumentative.
Not yet, I don't believe so, but do feel free to reurge the objection should it become argumentative. Counsel, you may continue.
I'll rephrase one more time. Are you still unsure sitting here today whether you had a conversation regarding football on the morning of November 13th?
Like I said, I just don't recall.
Pass the witness.
Redirect.
Redirect, Your Honor. Okay. Mr. Nelson, Is Mr. Barry a co-director with you of this, the fundraiser, the high school fundraiser?
No, it was something that I was organizing.
Is there a reason why Mr. Barry would be privy to everything you're doing regarding this fundraiser?
No, I was just organizing the fundraiser and trying to get donations, and Mr. Barry simply donated.
Pass the witness.
I do not allow recross in my court, so Coach Nelson, you may step down.
Thank you.
Is there anything further from the plaintiff?
Your Honor, if I may briefly just confer with my notes. Okay, I almost said co-counsel. Your Honor, the plaintiff rests.
Great. Do we have anything to take up with the court before we move into closing?
No, Your Honor, we're ready to proceed to vote.
Plaintiff?
Your Honor, the plaintiff urges earlier motions in regard for a directed verdict.
You still want a directed verdict?
If I could get one, Your Honor, it would make my day.
Not this time. Denied. Do we need a brief recess before closing, or are we okay moving straight in?
That would be appreciated, maybe like 3 minutes.
3 minutes is fine. We're off the record. Brett, Josh, y'all there?
Yep, I'm here.
Yes, I am.
There, we're good to go.
All right. We're back on the record. Both sides have rested. Defense, would you like to make your closing?
Yes, Your Honor.
You may proceed.
And may it please the court.
It sure can.
Cheaters never win. It may not catch up with them at the time, but no matter how they try to hide it, they get caught in the end. And that's exactly what happened here today, ladies and gentlemen of the jury. Now, at the outset, I hope y'all remember, opposing counsel came up here and they told you that they weren't gonna try to hide a lot of things. Now, I don't know if anybody else noticed, but opposing counsel sure objected a lot for somebody that wasn't trying to hide anything. So let's go through some of the things opposing counsel told you they weren't going to try to hide. Opposing counsel told you that they were not going to try to hide that Mr. Berry and Mr. Nelson were friends. But when we asked our witness about the photograph he found showing that the two were friends, they didn't want you to see that. I thought they admitted that. Opposing counsel also came up here and told you that they weren't going to try to hide that Mr. Berry donated to Mr. Nelson's charity. When we showed you that donation with this bank record, opposing counsel didn't want you to see it. I mean, we couldn't go 2 words without objection, objection, objection. It's like there were things they didn't want you to see. Now, he didn't mention these text messages. He didn't tell you he wasn't going to try to hide these. But Mr. Nelson did, and Mr. Berry did. When Mr. Berry was asked about these text messages, ladies and gentlemen of the jury, that you had already seen, that Mr. Berry had already seen, put up here on this screen already, he told you, I didn't text him. Right there on that stand, he told you, I didn't text him other than to wish him good luck. He's got to get in the game. That's a little bit more than good luck. Tell him to stop. That's enough. That's a little bit more than good luck. Now, when Mr. Nelson was asked about that phone call, he said they didn't talk about anything about football. They didn't talk about Nick Chubb. That's what he said on the stand. And even when he was shown his own deposition testimony saying directly that he told Mr. Berry that he was happy to have Nick Chubb back.
Objection, Your Honor. May we approach?
You may.
Your Honor, I hate to do this, but this is grossly misstating the testimony from earlier.
I agree that you have mischaracterized the testimony, but do you have a legal objection?
Yes, Your Honor, misstates, facts not in evidence.
Yeah, could I know exactly what testimony I'm mistaken?
Well, it's not really on the court to give you that information,
Okay.
but I will allow plaintiff's counsel 10 seconds to very specifically cite the information.
The testimony elicited after much ado was that he may have mentioned the game. Not that he did, and there was no inconsistency with his prior testimony.
Your Honor, if I may, An inconsistent statement is one that is not consistent with the testimony. He may have said it is inconsistent with him definitely saying it. I can rephrase what I just said, but it is still inconsistent.
On the stand, he said, I may have said that. In the answer to the interrogatory, he said he may have said that.
Yes, John.
That's what the objection is, and it will be sustained, but please do continue.
Thank you. So even after being shown his interrogatory that stated he told Mr. Nelson that he was happy to have Nick Chubb back, even on a limited basis, he said he may have said that. After he read it. Cheaters never win, no matter how much they try to hide. Now I want to talk about what we do know. We do know that Fred Berry placed a call to Haywood Nelson. We know they had a discussion that included information about Nick Chubb, and it included, should I be more specific?
I would appreciate there not being any crosstalk. Do please continue.
And we know that there was an offer to donate $64,000. We know that that same day, Mr. Berry placed a bet that is more money than he bets in a year. It's 11 times the amount of money he normally bets. He hit it hard. That's what he said on the stand. And then we saw on November 15th that he was texting Haywood Nelson during the game. He texted him, he's got to get in the game. He made a bet that Nick Chubb would score a touchdown. He also texted, tell him to stop. Mr. Berry's bet was that Nick Chubb would score exactly one touchdown. That's why he texted him that. Mr. Berry also needed Cleveland not to score any more points or he would lose his bet. That's enough. That's what he said. Or he would lose this $316,000. Now, opposing counsel asked our investigator some questions about the investigation experience. Also asked some questions about how familiar he is with sports betting. But ladies and gentlemen of the jury, I don't know how many of y'all are sports bettors, sports betting investigating experts. I don't know how many of y'all are football experts. But I do think there's an appropriate phrase from all of our collective grandparents here. And it's that I wasn't born yesterday. I don't think you need to be an expert to figure out what was going on up here. So now I want to take you through the decision you're going to be making today. This is your verdict form. You're going to go back in the jury room with this, and you're going to be asked 2 yes or no questions. First, number 1. You're going to be asked, did the defendant, Hard Luck Casino, prove by clear and convincing evidence that the plaintiff, Fred Berry, fraudulently placed the wages on November 13, 2020, or conspired to fraudulently place the wages on November 13, 2020? We know that he called his buddy, offered him money. His buddy at least told him he was happy to be back, happy to have Nick Chubb back, at least on a limited basis. And that the next day, Fred Berry sent $64,000 to a bank account belonging to Haywood Nelson. We also know that he also texted him instructions that lined up with exactly what he needed to win his bet. So again, I'm not an offensive coordinator, but I think we all can see enough to mark yes on question 1. Question 2. Is a question that has an even lower standard than the first one. This one just says, if you answered yes to question 1, then stop. So if you answer yes to number 1, please stop. And we are confident that you will. But even if you don't, even if you have to move on. The second question asks, did the defendant Hard Luck Casino prove by a preponderance of the evidence? So what is that? Ladies and gentlemen of the jury, the preponderance of an evidence, much like in football, is a burden of inches. If you think it's just 1 more inch closer to being more likely that Mr. Berry cheated, you're going to mark yes. And we've shown you way more than that. Again, Mr. Berry called the person that's calling the plays. Mr. Berry was texting instructions to the person who told his quarterback to tell Nick Chubb not to score. Now, the plaintiff counsel tried to make a little bit of a block between Baker Mayfield and Nick Chubb. But Mr. Hayward Nelson is the offensive coordinator. He called the play for Nick Chubb to get the ball. And so while, yes, he can only talk to Baker Mayfield directly, him passing that message on through Baker Mayfield is him effectively telling Nick Chubb not to score. Because Fred Berry needed Nick Chubb to only score 1 touchdown. Ladies and gentlemen of the jury, this is a case about fraud. It's not about the house always winning, as opposed to counsel telling them. Because the house deals with bets. It deals with waivers. Fred Berry didn't make a bet. Fred Berry didn't make a wager. He made a deal. He made a deal to pass his buddy along some money so that he could win a bet. And ladies and gentlemen of the jury, you know, cheaters never win. In the end, no matter how they try to hide it, they get caught. So once you go in that deliberation room and you talk about the case that you've seen, we are confident that you will reach the only verdict that the evidence supports and that justice demands. And that's that Fred Berry cheated and committed a fraud in his bet.
Thank you, counsel. Plaintiff, would you like to offer a closing?
Yes, Your Honor. May I set up the roll briefly?
You may.
May it please the court. Closing counsel. Members of the jury. I told you in the beginning, the house always wins. And I asked you, but why is that? This case was about a contract. Contract between the almighty casino and my client, Fred Berry. Now, Fred Berry, as you heard in the beginning, he's a guy who's good with numbers. He is a day trader. He is an avid sports bettor. This guy understands a betting line more than you or I ever will. Why did Fred Berry make these bets? This is why. Because a casino who needed to balance their books because of a mistake. Because of a mistake by Mabel King, the sports book manager. They enticed a bet. Fred Berry saw the call and answered. Fred Berry saw an opportunity, a legal, legitimate opportunity. And he put a lot of money on it. The casino just doesn't want to pay up. That's what we're dealing with. Now, I want to remind you of the burden of proof in this case. The casino is alleging fraud. And fraud is a big, bad, dirty word. It carries a lot of legal consequences, carries a lot of stigma. But that's why the law makes it hard to prove. The defense took on the burden today. A burden that, by the way, never left this table. The burden of clear and convincing evidence. It's only the highest burden available in a civil trial. And what the defense came with today falls far, far short. So let's walk through it. Now, the play that started it all, the step heard around the world, was Nick Chubb stepping out of bounds instead of scoring a touchdown. A play call not to score, to not give the ball back to the other team. It's not hard to think back to many an NFL game where somebody did exactly that. They scored, the other team got the ball back, scored quickly, onside kick, score again. An offensive coordinator who's seen somebody get burned will call a play just like that. There's nothing wrong with it. There's nothing suspicious or weird about it. It's called football. The guy who has the most points at the end of the clock running out to zero, that's the guy that wins the game. That's the team that wins. Now, the defense came to you today with texts and phone calls and Facebook. I told you in the beginning, we don't care. We don't care about that. And I'm going to tell you why you shouldn't care about it. Fred Berry knows Haywood Nelson. And so what? You don't get to the high bar of fraud, clear and convincing evidence of intent, of a misrepresentation, of a fraudulent act. You don't get there with phone calls and a Facebook post. You don't get there by saying this guy made a bigger bet this one time than ever. Again, so what? So what? Now, we talked about a fundraiser. This is a fundraiser. This is a fundraiser that Haywood Nelson started. This is a fundraiser, and as far as Fred Berry knew, was legitimate, and he was giving to a good cause. Fred Berry is a philanthropist. He gave to a good cause. Now, if Haywood Nelson hasn't paid the school, or if the school hasn't authorized it, that is not on Fred Berry. Fred Berry, I asked Haywood Nelson, is Fred Berry a director, a co-director? Are you guys in this fundraiser together? No. This is something Haywood Nelson took on. My client is Fred Berry. The person who's being accused by the casino is Fred Berry, not Haywood Nelson. Now let's talk about the witnesses that came from the casino. I want to start with this, D. Thomas, this guy. This guy has made $550,000 in the last 3 years, pointing the finger at people. He points and he gets paid. Point, get paid. This guy gets a 5% bounty. He's a glorified bounty hunter. He's an ex-bouncer, card counting, catching security guard, glorified security guard. That's exactly what he is. I asked him, what's your investigatory, what is your experience? Did you interview anybody for this? No, man, didn't interview anybody. Well, isn't interviewing kind of an important part of investigating? No interviews, didn't talk to anybody, didn't ask anybody any questions. You're saying someone sent a text during a football game? So what? Haywood Nelson had his phone in his pocket. He didn't take it out. So what? And then we've got Mabel King. Mr. King came and testified that the books were not balanced. Mr. King testified he could lose his job, the job he's had a long time. $80,000 in the hole. Got to pay off the high rollers, the diamond medallion bettors. Got to pay all these people for bad beat insurance. That's a lot of reasons to have to point the finger. And my client was the scapegoat. Now, I want to pull up the jury charge, if we could. This is the form opposing counsel has just showed you. Opposing counsel has done a wonderful job today. And I just want to go over this form. We're going to have a little bit different answers for the form than opposing counsel did. So before we pull that up, I just want to remind you, there are 2 questions on this form. You answer them with yes or no. Question 1 asks this. Did the casino prove by clear and convincing evidence that Fred Berry committed fraud or conspired to commit fraud? Did the casino prove? Let's look and see if the defense, the casino, earned the answers they're asking you for. Now, remember, everybody they brought to testify had a financial incentive. Mr. Thomas is going to make 49 grand if you write yes in that blank. The guy who didn't do any interviews, doesn't know how to investigate, save his life, that guy's going to get $49,000 if you just pin in yes in that box. Did the casino make their burden? Did they prove that to you? If you answer no, as I think you rightly should for question 1, you go to question 2. Question 2 says, did the casino prove by a preponderance of the evidence? Okay, so a little bit lower of a burden, clear and convincing on fraud. Preponderance is on this one. Did they prove by a preponderance that Fred Berry created irregularities that caused the legitimacy of the game to be in doubt? Let's remember, all they brought you is a phone call and Facebook post. Oh, and a fundraiser. A fundraiser, that's right. That is not convincing of anything. The answer to question 2 should be no. Members of the jury, your 2 no answers on this form are going to do something very important today. Goliath, the casino, owes David money. The casino makes all the rules for the bets. They can change the game, they can change the rules. They got the money. And when they have to pay up, boy, it's hard to get anything out of them. Opposing counsel said, cheaters always lose. But the real story today is not that cheaters always win or lose. The real story today is that casinos, the house always wins. Please give Fred Berry justice. Thank you.
Thank you, counsel. Remind me, defense, did you reserve time for rebuttal?
Yes, Your Honor. And I believe I have like 6 minutes left.
Just try not to use all 6, but
I don't think I will. May I proceed?
Yes, sir.
Ladies and gentlemen of the jury, I know this has been a long trial. I don't want to bore you by walking you through excruciating detail again, through the law and through the charge that you've been given to go deliberate and the questions that you have been asked to answer today. But I would like to remind you that one of the things you're going to find when you go back and you go and review the law is that it is illegal to try to cheat. So even if Mr. Berry was unsuccessful, which it sure looks like he was, all he has to do is try. Opposing counsel told you all we bought you were texts, Facebook posts, and phone calls. That's all. We have this text of Fred Berry texting Haywood Nelson during the game, giving him instructions. It doesn't matter if the phone was in his pocket. It doesn't matter if his phone was in his hat. It doesn't matter if he threw his phone out the press box. It doesn't matter because, as he said, this case is about his client, and his client tried to cheat. Now, opposing counsel brought up the employment history of Mr. D. Thomas, who has worked hard and for a long time to get where he is, who is certified as a private investigator. But he called him a glorified security guard. Well, ladies and gentlemen of the jury, I don't know what your occupations are, but I do know that a security guard, a crossing guard, any other kind of guard you want to have could read those text messages. I don't think you need extensive experience to read the words on that screenshot. I don't think he needed to ask Mr. Berry anything about that text because that is clear and convincing evidence that Mr. Berry tried to manipulate the game during the game. And that's not even talking about the phone call and the promise of the donation that actually went to Mr. Haywood's bank account for the charity that is both unauthorized and has yet to do anything charitable in over the years since he started the charity and gotten the money. Again, ladies and gentlemen of the jury, we were not born yesterday. So again, we are confident that once you go in that deliberation room, you will check yes. To both of these questions, because you do not have to be Sherlock Holmes to read those texts right in front of you. Cheaters never win. They get caught. Mr. Berry got caught. That's what this case is about.
Okay, great. The jury will go back and deliberate. We're off the record. Thank you all very much.
Thank you.
All right, thank you. That concludes the trial. We're gonna ask the competitors to step out while the scores are tabulated, and then we'll invite them back in for comments, feedback, and we'll announce the winners. All right, we're back on. We're ready to announce the winner, but first, again, let me thank the judges. If you could both turn on your cameras. Honorable Brett Hargis and the Honorable Joshua Bennett. We really, and of course, our presiding judge, the Honorable John Herman. Thank you, all three of you, for judging, being here, being able to give critiques and feedback. Let's go ahead and hear from you.
I don't appear to be able to turn my video on, but
That's fine. That's absolutely fine.
I think I'm cut off on your end,
Oh,
but
I'll fix it. Hold on.
no big deal. There we go. There we go.
There it is. Now we have.
Okay.
All right, so it's comment time.
Yes.
All right, well, I'm gonna keep it brief because I know what y'all are waiting on is to hear who won, so I'm not gonna like delay that for too long. Everybody, I enjoyed this. Everybody did as I'm sure you know, did a good job. These are the finals, so I'm not surprised that we saw a good showing from everybody. My take was that in general that the plaintiff, I could follow his opening and closing statements really well and easily. I thought it was well laid out. I don't think it matters too much for this forum, but I'll tell you in a real trial, if you're going to object, make sure that you are only objecting about the most important things and that you are right, because a judge and a jury will start shutting down if you're just objecting a lot. On the defense side, I thought the cross exams, well, and direct too, were quite good, especially Miss Brayhun, is that your last name?
Yeah, Brehan is fine.
Brayhun, okay, sorry. I thought you did a great job on the cross. I think the only criticism I have at all is I think once you made your point, get in and get out, and you can beat a dead horse a little bit, but all in all, great job, and I enjoyed it, and I appreciate y'all letting me judge it.
Yeah, I'll keep mine brief too. But guys, y'all did a great job. I know it's, middle of November, you're getting close to getting ready for finals, but y'all were extremely prepared from what I could tell. I did a lot of these on Zoom, didn't get to do as many in person, but from my bird's eye view, what it looked like is y'all were relying very little on notes and used the well very effectively. So great job on that. Just a few comments. The demonstratives, those were good. It's always good to do the horse and pony show. Don't overuse them though. I think maybe sometimes they weren't as necessary, but just to give an example, the investigator, D. Thomas, I thought both the plaintiff and the defense's use of the flip chart on that was very effective. So good job with that. Everybody work on impeachments, and that versus refreshing recollection, that's tricky. Y'all did a pretty good job with it. Just keep working on those, with your foundation questions you need, and when, which of those methods is appropriate. And then one other thing, redirects, people have differing opinions on them. I think there were a few witnesses in this case where a redirect might have been appropriate, and then a couple of times where maybe not so much, but just something to keep in mind. In some tournaments, you're judged on redirects, some you aren't. So that's something to keep in mind too. Like Josh said, I really enjoyed this too. I actually tried this case in the tournament it was used a couple of years ago. So it was fun for me to, see what y'all did different. I will say y'all did most of the stuff my teammates and I did, including the themes. They were all very similar. So, no matter who won, y'all all did a great job, and I commend y'all for, putting in the time and effort and doing this. It's always a good time. It's fun for me to come back and judge now. So great job, everyone.
Yeah, I'll reiterate, great job. I'll
give you a couple of nitpicks because y'all did a good job. I don't have any huge criticisms. These are all pretty fine tuned. You should get rulings on your objections for the record. I purposefully, if I could get away with it, tried not to give you a ruling. And I think both sides let me get away with it a whole lot. You should try to respect the formalities of a court, even though this is a very poor representation of a court. The one that bugged me the most, I think, was the crosstalk. I kind of let y'all get away with it a few times early, but then as the trial went on, it got a little worse and worse. You don't want to bicker with opposing counsel in front of a jury because the jury already thinks lawyers like to argue. You want to be overly respectful and helpful if you can. So, you know, a good example of that was sharing the marker, sharing the flipboard, doing that very well. But, you know, for example, Josh, your closing, almost all of your points were opposing counsel said this. I would just tweet that and say, plaintiff told you this. And then you're talking about the client, not the lawyer. And then your points are much more effective, in my opinion. Overall, great job. A lot of objections on both sides. He objected a lot. A lot of them were nonsense, but I thought y'all did a good job of responding to them. And a lot of them were really good objections. And you stuck with it, even if you didn't get the ruling you wanted at the front end. So very good job all around.
All right. The ballots are in, the scores have been tallied. We have a winner. I'd like to congratulate Jeff Krumpholz, the winner of the 2022 Hippard Open mock trial competition. A special note, he did it all by himself, trying the case all 5 rounds alone. Congratulations, Jeff. A special note to our semifinalists, our finalists, runner-up, Autumn Brehan, Joshua Hunter. Great job to you both. I saw such a great trial today. Great judges, just a great mock trial in general. So thank you all for being here, participating, watching, judging. We hope to see you again next year.